Okay, how to survive an OSHA inspection. This is our agenda for the day. Got a lot of slides. There's a big slide deck here, but a lot of the slides are pictures. We're going to move through it quickly. I would encourage you to interject at any time you've got questions for either me or for Pat. So don't hold your question until the end. We'll address it. I would expect that we would have quite a few questions, and please go ahead. There's our title slides. What I'd like to do is give you a little bit of an update on OSHA. And what does OSHA today look like in the Biden administration? Well, quite honestly, it looks a lot like it did during the Obama administration, which is no surprise since Biden was Obama's vice president. One of the things that OSHA is looking at doing, the wheels of government turn very, very slowly. So when you hear about proposed regulations, it takes a long time to get from a draft regulation until it becomes a final rule. One of the things that you should be aware of is OSHA is looking at modifying the record-keeping requirements again. What this would do is require employers with 100 or more employees to file detailed information electronically from the OSHA log. It's not in effect yet. So essentially for record keeping, if you're familiar with the OSHA record keeping requirements, there'll be triggers for record keeping at 10, at 20, at 100 if this comes in, and 250. And that's meant to simplify things for folks like you. The more criteria we have just adds complication to this. It's not in effect yet. The problem is for companies with 100 or more employees, if this goes through, another thing they plan on doing is making this information from your OSHA log public so that anybody can go on the OSHA website and see the information regarding your health and safety program statistics. Something else that was done during the Obama administration that we actually had clients, unfortunately, fall victim to is the agency's practice of shaming employers through press releases. So bad enough that you perhaps had an incident that resulted in an OSHA inspection, but to pour salt in the wound, we really don't want the agency doing this public shaming. And unfortunately, as I mentioned, I had a couple of clients that fell victim to that. There were also some provisions in an older version of the record-keeping standard that the Trump administration did away with, but it appears that the Biden administration may return to, which is enforcing restrictions on safety incentive programs and reinstating limits on post-injury drug testing. So these are not in effect, but there are things that could be coming down the pike. People may remember that we went through a period of time where OSHA was looking to implement a COVID standard, vaccine requirements. Well, that was overturned. What OSHA's looking at doing is coming up with an infection. It's on the radar for May. I doubt that's going to happen. Probably won't even happen this year. An infectious disease standard that would include COVID. So typically we look at infectious disease standards as they apply to the healthcare industry. This, if it comes out, would cover all employers and would include COVID. Something else that's pretty high on OSHA's radar is a heat stress standard that would apply to the construction industry as well as general industry. Again, it's not been published yet. It's on the radar. We'll see if that comes out this year. One of the things that you need to understand about OSHA is that OSHA operates in 10 different regions of the country. Colorado is in OSHA Region 8. Each of the OSHA regions select and pick different points of emphasis, different hazards that they want to focus on. So I thought it would be important for everybody in the room to understand what Region 8's emphasis programs are, which would include noise exposure, but not in a construction environment. So this would be general industry, forklifts, powered industrial trucks, work zone safety, construction work zones, roads work zones, and falls. Falls has been on OSHA's radar for a long, long time. So those are the things in this region that the offices, area offices, will be focusing on. So one of the questions, why are you here? Well, you're here to figure out how to get through an OSHA inspection with the least amount of difficulty possible. And the reasons, number one, maybe not the most important reason, but one of the reasons is financial. The OSHA penalties are a lot more today than they were 10 or 20 years ago. It was kind of ridiculous. OSHA would have the same. I was told by clients on many occasions it's actually cheaper for me to pay the fine than it is to comply. Well, that's changed. That was 20 years ago. It's a different situation today. Something else you should know about is an OSHA inspection becomes part of your permanent record, publicly available. I don't think we have a slide today to show you how to do that, but if you go to the OSHA website and do an establishment search, put in the name of your company, put in the name of a competitor, and you'll see all the inspections that were conducted of your facility since OSHA came into being in the 70s. It's used in business relationships. How many of you are in construction or construction-related businesses? One of the things that your clients could do is to search your OSHA history. And there's red flags. One of the big red flags would be willful violations. But if your company has been subject to OSHA inspections and there's a willful violations, there's a possibility that potential client of yours will say, no, thanks, we're not interested in you bidding this job. And I've even heard stories of insurance underwriters actually taking a look at the OSHA history, because if an underwriter takes a look and you've got multiple violations for the same thing repeatedly over and over again, they look at it from an underwriting perspective and may say, we're just not comfortable taking the risk on this particular account. So a lot of good reasons to avoid an OSHA inspection when you can, but the purpose of the workshop today is to help you prepare what to do. How can I get through this with the least amount of pain possible? So, if you're willing to share, how many of you have been inspected by OSHA before? So a handful of people. Is there anyone willing to admit that you felt like you could have been better prepared? Yeah, I thought maybe the hands wouldn't go up for that one. Another question, if you were subject to an inspection, could the problems that OSHA found, could they have been potentially prevented? Which is another thing to ask ourselves. And all this is, I'm working towards an objective at the end of the workshop today. But if we address these things in a reasonable manner, not overboard, you can really do a lot to protect yourself. And the last question is, in my experience, it's been the actions of the employees during an inspection that result in a great number of citations. So, once again, by show of hands, how many of you are frustrated that the actions of your employees can expose you to the possibility of an OSHA inspection? Because that's what, especially in construction, we'll talk specifically about industry, we'll talk specifically about construction. But in construction, you can drive down the road. How many of you look for, those of you safety geeks in the room, how many of you look for violations when you're driving? Easiest one to spot is the ladder to a roof and it's stubbed up 1 foot, right? That's a violation. And you can see it. You can see it easily from driving around. So is that an unsafe condition or was it an unsafe behavior? It's kind of both. but it was the behavior that caused the unsafe condition. Had the employee run the ladder up 3 feet, there would be no violation. So visibility, especially in construction, is huge.
Here.
Sure.
For those of you who don't know, hi, Pat here. For those of you who don't know, the Denver area office and the Inglewood area office are doing Saturday patrols. So they're sending compliance officers out on the weekend where there's little to no management oversight, and they are just picking apart mostly residential construction. And I've had many cases that resulted from that. And Gary's right. It's usually the employees, hey, the cat's away. We're going to, kind of cut corners here, and they're dinging people for it. So beware.
Yeah, government works on Saturday. And as Pat mentioned, residential construction, and I've taken photos of various hazards in residential construction, and a lot of challenges there compared to commercial construction, and that's one of the reasons why they're looking at residential construction. Here's the top 10. I'm not going to go through them in detail. You get a general idea of what they're looking at, and the list basically stays the same year to year. Maybe some of the different standards flip-flop here and there, but that's basically what OSHA's looking at. That's basically what the majority of employers are doing wrong. So let's take a look at the inspection process, kind of look at the reasons why OSHA does inspections. Here's the list. We're going to go through these in detail, but there's a lot of reasons why OSHA can show up at the door. A lot of people tend to think that it's all based on complaints, and a fair number of inspections are based on complaints, but there's more reasons than that. We're going to look at each one. So one of the first reasons is a fatality, catastrophe. They've expanded this list, so it includes of any work-related fatality on the job site. You're required to provide notice within 8 hours. With a hospitalization, overnight hospitalization, not including overnight hospitalization for observation. Get a little bit technical in the detail, and I don't want to waste a lot of time talking about those details. But also, anytime you have an amputation, but that's a complete amputation. If somebody loses the tip of their finger, but it's hanging on literally by a skin cell, and they flop the finger back into place and put it back into place without that finger, it's called an avulsion. An avulsion is not required to be reported. It has to be a complete amputation. So knowing the different aspects of each of these are going to be important. The loss of an eye, but the loss of the eye organ, not being blinded. So OSHA is only concerned if you actually lose the eye organ. If you become blinded but keep the eye organ, the way I read it, it's not required to be reported.
Yeah, and what they did there is they had to draw some lines in some pretty random places. So they took definitions from an old Bureau of Labor Statistics rule, and Gary's right, there's some weird lines that are drawn. So for example, if you do lose the tip of your finger, it comes completely off, even if there's no bone loss, that is an amputation, but you could be literally scalped, and you have a machine cut off the top of your skin, but that's not reportable. So lines are drawn in weird places. Now, granted, if you get scalped, you're more than likely going to be admitted to the hospital for treatment, so that's a separate reason to report. But yeah, look at those definitions carefully, because one of the biggest mistakes I have clients do is over-reporting to OSHA. They call in things that they didn't need to. For example, the 24 hours. If the person who's injured is not admitted to the hospital within 24 hours of the incident, you don't need to call that in. So look for those kind of timelines, because you don't want to buy yourself an inspection when you don't need to.
Yeah, and I would encourage you, if you have any questions, obviously, many of you have dual roles at the companies that you work for. We don't expect you to know these fine details, so I would encourage you to reach out to Pat or myself if you have questions regarding specific details like that. Certain things OSHA won't investigate. If there's a fatality, a work-related fatality on a public road, they don't come out to investigate that, because that's jurisdiction of the police. So if you have an employee, unfortunately, who's killed on the road, no need to call that into OSHA. It obviously goes on the OSHA log as a work-related fatality, but it's not something you have to phone in. Another reason for inspection, quite honestly, is just a high-profile accident. Not unusual if there was an accident that attracts media attention that OSHA becomes aware of, they may go out and inspect that. So when you have these incidents occur, especially on a construction site with multiple employers working there, if there's a high-profile accident, you need to be aware of the fact involving another contractor, OSHA could show up on that job site. So it's just something to be aware of. Typically, the bigger job sites like that, if something happens, your foreman or somebody on the job site is going to let others know what's going on, or they're going to find out about it. It's not unusual for public entities like fire departments, police, hospitals to contact OSHA themselves and say, we've had a work-related incident that we're treating here. So anytime there's been a bad accident at a job site, I would have your head on a swivel and be prepared for a potential.
Wait, Gary?
Sure.
With the reporting timeline, so you have 8 hours for a fatality, 24 hours for a hospitalization. If there's law enforcement involved or EMS involved, it's more likely than not that they're going to call OSHA. Even if you know they've called OSHA, you still have that obligation as the employer. And a bit of practical advice is don't wait till the 7th hour to report it or the 23rd hour on a hospitalization, because that'll frankly just piss them off. And, they want that call early, even if they already know that the incident occurred.
Yeah, that's great advice. Actually, excuse me, got a problem with my voice. Not good when you're talking for 2 hours in the morning. What to do following a bad accident? So obviously, our biggest concern is to care for the injured workers. So call 911 immediately. No guesswork there. If it's exercise judgment, we don't want to overkill, but we certainly want to take care of somebody who's injured. Assist EMS in getting to the injured employee. I do want to defer to Pat here to talk about an issue. You want to secure the accident scene. You want to make sure that nobody else gets hurt, but you also want to secure the accident scene. One of the reasons is to secure evidence that might be needed. There's something called spoliation of evidence. And Pat, do you want to talk a little bit about that?
Okay, one of my favorite topics. So spoliation of evidence is a legal rule, essentially, that says that once you're on notice that litigation it can be reasonably anticipated, you're under a duty to preserve potentially relevant evidence. And this is probably one of the most important things that comes up in an OSHA inspection, because there's a lot of moving parts when something has happened. You're worried about the safety and health of your other folks. You're worried about your injured employee. You're not really thinking about some of these things. But to the extent that you let the machine go back into service or be repaired if it was involved in the incident, or if you let a contractor drive off with a truck that might have potentially relevant evidence. Quick war story here. I had a case that involved an explosion up in Weld County. 2 people were killed, 3 were badly injured. And we got into a spoliation dispute because one of our subs took off, and it was kind of under fishy circumstances, just took off in his truck. And our speculation, there were reports that that individual didn't seem right during the shift, and he was a welder that was involved in the accident. So we maintained that, hey, you, our sub, spoliated that evidence because law enforcement could have found drugs in there, alcohol, whatever. So it really is important to secure the scene to avoid a spoliation argument. And this is not just physical evidence. This is electronically stored information that might relate to the accident, business records, all those things that you would normally otherwise turn over in the normal course of business, you need to keep. And the penalty for not doing that is what a judge can do down the road, whether it's in an OSHA case or civil litigation. The judge can tell the jury, hey, let's do an easy example, an email. Say the plaintiff's family sues you down the road and says, you know what, we think there was an email there from company ABC saying we're going to be unsafe today and hurt our employees. Obviously, that's ludicrous. But company A, B, and C didn't save their emails. And so if they, and they, whether it's on purpose or negligently, if you spoliate that evidence, the judge can instruct the jury to say, company ABC had a duty to keep its emails. They did not. So you can infer, you don't have to, but you, the jury, can infer that that email says exactly what the plaintiff's lawyer says it said. Or in my case, we would be, in that case, didn't go to trial, but we would have been able to argue, hey, because this subcontractor took off with his truck, we maintain that there were contraband in there was alcohol in there. Because they spoliated that evidence, you, the jury, can infer that that's why they did it, whether it's accurate or not. So spoliation is one thing I get on my high horse about because it really, really causes problems down the road. So that's why, especially in a significant incident, it's really good to get crisis management folks involved, your in-house counsel or outside counsel, anyone who's going to be able to look at the scene and say, okay, here's what we need to keep. You need to work with other entities on site because, frankly, you don't control everything. My client could not have stopped that guy leaving in his truck because it's not our truck. But in those situations, you document it carefully. Okay, here's employee XYZ who took off in his truck at this time. We took a photo of it, that whole thing. So it really is a way for the parties to get together because we all have the same interest when it comes to retaining evidence. We all want to get to the truth of it because what will happen is OSHA will want to do testing on equipment. They'll want to do metallurgy if that was involved. So you need to preserve it. You need to get protocols going, and it can become a long process. But if you let that go at the instant of the incident, it's big trouble down the road. So, end of speech.
There's also an obligation to third parties who may have potential liability.
Yeah, absolutely. Carriers, that's another thing that should go on this list of what to do in an incident. One of the first things you should do is call your GL carrier and get them on notice.
I have a really sad story. So I had a client back in Chicago, and they warehoused and distributed a variety of construction materials. One of the things they got were crane mats, giant crane mats that were shipped on A-frame rail cars. And in this particular situation, the 18-year-old son of the owner's best friend was employed to work at this warehouse and rail sidetrack. They were unloading these crane mats, and the crane mats were strapped with metal straps to the rail car. So this young man, his job was to go in and disconnect or snap the steel straps that were holding these crane mats, 7,600 pounds, I think, each bundle, to the rail car. Well, it was wood, and there was stored energy in those crane mats. So when he finally snapped the last band, there were people that were around him. He had earbuds in, and he had the earbuds at full volume. They were screaming. First of all, the way they did it, when I pulled up, I was upset because when I realized how they were doing this, it was insane. Anyway, 7,600 pounds of crane mats fell on him and crushed him. And the owner had to go to his best friend's house and inform him and his wife that his 18-year-old son wasn't coming home again. So back to the spoliation part, it was shipped on a rail car. It was loaded by others. All those parties had to be notified of this incident to give them time to investigate the incident.
It can get really complicated.
So on top of everything else, dealing with this fatality, an employee, young man, you have these other issues that you need to be concerned about. So probably good advice from Pat is notify your general liability carrier. You're going to want to take extensive photos of the scene. You're going to want to get as much information as you can. To Pat's point, you don't want to call 7 hours and 59 minutes following a fatality, but you also don't want to call in the first 5, right? You're going to want to control the scene. You're going to want to learn as much as you possibly can about what happened before you make that call to OSHA.
Yeah, that's right. Last thing, you don't want to be getting evasive facts with the OSHA compliance officer standing next to you. You want to have the information as much as you can glean it out before they show up. Not for nefarious reasons, but you want to know where the sticking points might be, and to the extent you can, maybe steer OSHA away from that. And frankly, you're not always going to be able to do that. But again, you don't want to learn something on the fly with a compliance officer right next to you.
Another reason for inspection would be complaints. Complaints can come from the employee, can come from the union. I've been involved in a couple of those. Can come from a referral. It's not a good referral. Usually you want people to refer business to you, but not that kind of business. The unfriendly competitor is second lowest bidder, right? They don't get the job, they're going to get even. And written complaint.
I've had a couple recently that are homeowners in the neighborhood that don't like the construction that's going on. Oh, look at that trench. Maybe OSHA wants to take a look at that.
Yeah, been involved in a couple of those too. In many cases, probably the majority of cases, most complaints are phoned in by employees or ex-employees. In fact, it was really interesting. I was involved in one case that really didn't go very far. It was an ex-employee who was terminated for continuous safety violations. And he turned around and called OSHA and said there's hazards with the employer. So the ultimate irony, right? The one thing you should be aware of, though, is when the OSHA Act was written, if an employee bothers to write a complaint, that must result in an on-site inspection. So if you have employees that know the OSHA law to that extent, you're going to get the inspection if they write the complaint.
And to Gary's point, and I don't mean to be cynical here, but more often than not, it's a disgruntled employee who may have performance issues, sees the writing on the wall, and all of a sudden gets very educated about the OSHA Act and its anti-retaliation provisions, and there you go.
So I do want to talk about how many of you have received notice from OSHA through email or a phone call that they had received a complaint from an employee. And if you don't mind me asking, were you able to resolve that without them coming on site? Yes. So, situation, OSHA phones the employer, says, we received a complaint. They email the specifics about the complaint. Was it by email that they sent it to you?
Email and phone call.
Email and phone call. Outlining what the specifics of the complaint were. You have an opportunity to make that go away without OSHA visiting on site. So they're going to email you specifics. You can either deny the allegations. It's always good to provide evidence. The more evidence you can provide, the more likely it is that OSHA is going to understand that the complaint was not founded. So whatever you can do to provide evidence to the contrary. Employee wasn't trained in forklift operation. You can elaborate that you've conducted the forklift operator training. You could include the log of employees that were included in the forklift training. You can include pictures. However, I am going to caution you to be very careful with providing pictures to the agency. You wouldn't want to show a picture of a machine that was properly guarded, and then there's a maintenance person standing on the top step of a stepladder in the background. So you need to think like a safety geek, and when you take the picture, look at the picture very carefully to make sure that there weren't other hazards that weren't part of the picture.
Responding to these is tricky because, as Gary mentioned, more often than not, I'd say 9 times out of 10, if the one you get is what they call a rapid response letter or fax for back in the old days.
Yeah.
And you provide appropriate documentation, it's probably going to go away. So when I look at these and advise clients, a lot of clients say, okay, an example, a machine guarded complaint. This lathe isn't guarded. We look at it, and that's right. The employee who complained about it was correct. So we fix it, take a picture, send it to OSHA. Some employers are hesitant to do that because, well, it admits the violation. Well, you fixed it in good faith, send it into OSHA. They're probably not going to come out and cite you on the basis of that admission. OSHA really does that. They don't want to waste their time, so to speak, with the non-accidents and things like that. So when you get these complaint letters, even if they kind of caught you on something, fix it and send in the documentation, and way more often than not, that's the end of it. If you try and get cute and say, well, or kind of take weird angles on your photos or make certain arguments that just don't fly, that's what's going to raise their suspicion and get them out there. So most of these, just in good faith, fix it, show them your documentation, and it'll go away.
Yeah, great point. That OSHA knows that they get used, and they don't like that. They know that they get used by people in a don't get mad, don't get even scheme. And no better example of that, I was involved with a demolition contractor who was working on a building in downtown Chicago, and they were taking a scissor lift by tower crane and lowering it to the ground. And one of the, I think it was the steward for the ironworkers, Local 1 in Chicago, decided to jump into the scissor lift on its way down from the building. He jumped from the building into the scissor lift to ride it down to the ground. And his big joke was, haha, I just took the elevator. So this became knowledge at the job site, and the general contractor told the iron worker, the steel erection contractor, he's gone. He's banned from the job. And the steel erection contractor, well, he's the steward, and you don't mess with Local 1 in Chicago. So they said he needs to go back to the job, and the general contractor said no, he's not coming back to the job. So I think the next day, OSHA received a written complaint from the ironworkers union, and the nature of the complaint, the demolition contractor was cutting steel. It was an expansion to the building. They were cutting steel. It had been abated. It was lead-based paint. It had been abated where they were cutting the steel, but the complaint from the ironworkers was that their employees were exposed to lead fume. So the industrial hygienist from OSHA came out, did an inspection, did sampling. There was no problem. The union called and said, will you take the steward back? And general contractor said, no, we're not going to take him back. Written complaint number two. The iron workers were complaining about the noise levels they were exposed to. So the same industrial hygienist came back to the job site, and I'm here to investigate a noise complaint. Well, no foundation of the noise complaint. People were wearing hearing protection. There's no hearing conservation standard for construction. So they went away. You're going to take the steward back. General contractor said no. Third written complaint. The exhaust from the concrete trucks that were on the street below was making the iron workers nauseous. So she showed up. You know what the sad part of the story is? You know what happened? The steward came back on the job. They were abusing the written complaint process just simply to make their point, and the steward ended up back on the job.
With an unsafe worker back at your site.
Yeah. Let's be proud of that, right? So the agency doesn't like to get used, and she knew it. The industrial hygienist that came out knew she was being used.
That's a very Chicago story, by the way.
Glad to see
that kind of level of abuse here.
Happy to be in Colorado.
There are some sort of standards in place that say, the OSHA says, well, obviously they're being vindictive. We got to cut this off. There's nothing like that. They have to adhere to that. I mean, where's that?
Yeah, I mean, as Gary pointed out, if they get a written complaint, they're going to show up. But as a practical matter, once you get to that third or even second, okay, I'm here. Yeah, we know what's going on here. Let's look at the site real quick. We've satisfied our obligation for the inspection. Another option an employer has, and it's one that I don't really recommend, is you make OSHA go get a warrant. Even on an employee complaint, they're supposed to show up. They don't get to come on your property unless either you allow them to or they obtain a warrant from federal district court. In all the years I've been doing this, I've never advised a client to get a warrant. But that's one thing you could do, because you know what the OSHA compliance officer might do is say, we're not going to waste our time with this.
Good point.
Get a warrant.
Great point.
So, again, it would have to get pretty extreme for me to advise the client to do that.
Yeah.
OSHA's getting you ready to and again, they're going to come in and turn the whole place.
Wow.
So, but that is an option.
Yeah, that's usually kind of putting your fists up when you demand the warrant. And they'll come back and they'll be thorough. So it's funny you mention that, because I don't even discuss asking for a warrant in the presentation.
I've never done it. I've never made OSHA get a warrant.
Programmed inspections. There are programmed inspections. There are random inspections still being conducted. I would argue that there are more inspections being done. Like, what really caused the agency to get busy were the changes in reporting amputations and hospitalizations. It really escalated their inspection activity, as well as special emphasis programs. So special emphasis programs that we see pretty much all over the country would be fall protection in construction, amputations, silica in construction. These are developed at national, regional, and even area office levels. In construction, probably the number one reason for inspections would be drive-by. Compliance officers are on the road like all of us. And when they drive from point A to point B, if they see a hazard, they call it into the office, ask for permission to proceed with an inspection, and there you go.
And this is anecdotal, and I won't name names, but I did have a compliance officer tell me fairly recently that their informal practice, whether it's unsafe or not, if they see an excavation anywhere where they're driving, they will stop. And maybe the excavation is fine, maybe it's not, but if you cut a hole in the ground and you're next to a road, you can anticipate that if you're unlucky enough to have a compliance officer coming by, they will stop.
Yeah, for sure. And maybe one of the most suspicious job sites is an excavation job site with the trench box outside of the hole. I mean, if you're going to have the trench box there, you might as well put it in the hole and use it, because if there's an excavation with the box out of the trench, that's kind of like, what? What's this all about? So just understand your construction site. And the problem is, for many of you that work on multi-employer job sites, is it may not be your hazard. It may be another subcontractor's hazard, but that's going to draw OSHA onto the job site. And honestly, in construction, they have the evidence before they even come onto the job site. If they can take pictures from a public area outside of the job site, they have the evidence before you even know they're there. So, and I've been part of those inspections where people denied the hazard, and OSHA will start flipping through the pictures.
And I think if they do a lot of that, if there's a really unsafe excavation and OSHA spends a half hour outside of your job site taking pictures of it, I think that's a little bit in bad faith if it's that hazardous. Come in and make the employer aware of it. But Gary's right, they do have a legal obligation, or legal right, I should say, to do that, to just sit outside of your site before they come introduce. They only have to introduce themselves when they come onto your property and show their credentials and all that. And then they do it, and that's perfectly admissible and perfectly legal.
Something else, if you attended the record-keeping workshop we did back in January, I talked about this, but site-specific targeting. Essentially, what OSHA's doing is they're looking at the information that's being filed electronically on the OSHA website. It's kind of interesting because they don't actually ask you to calculate the incident rates, but they collect the information they need to calculate the incident rates and then compare it against what you've identified as your peer group, the NAICS code. And if your incident rates, especially the DART rate, the days away from and restricted worker transfer, that rate, then if you're above your peer group rate, that could target you for inspection. This program started probably, 15 years ago, but it was an informal process. And they actually published the names of the companies that were on that list. They're not doing that anymore.
No, as a practical matter, and Gary's right, once the new reporting requirements came in, OSHA had to spend so much time responding to reports that they don't have this doesn't mean they don't do it. They do, but these are a little bit less frequent than they used to be.
The rest of the reasons, do you want to talk about the...
Yes.
All right, here you go.
All right. This is a program that came out from OSHA in the Obama administration. It's always been there. During the Trump years, they didn't use it as much. But it's called the Severe Violator Enforcement Program, or SVET. And there are certain criteria that get you on it. Like it says here, 2 or more willful or repeated violations of a high-gravity, serious nature. I'm working one of these right now in the Midwest. And actually, I had the very first case under SVET where the client finally got off of the list by waiting it out a few years. But it's a ridiculous program in my view. And the main reason is because you get on this list whether you've violated an OSHA standard, acted willfully, or any of the allegations or not. This comes out once the citation is issued, before you even have a chance to contest. What they do, it always comes with a press release. They say company ABC willfully violated the standard and an employee died. We're fining them $500,000 and we're putting them on the severe violators list. Well, that's an awful, awful press release. And more often than not, it gets picked up, at least in the local area where the incident occurred. And once you're in that, again, with no rights whatsoever, OSHA just decides to do it. This is not a creature of statute. This is not a regulation that went through notice and comment rulemaking. This is just something OSHA dreamed up as an enforcement policy. But once you're on it, you can't get out of it unless you either win it in court or you're able to settle under terms that would take you out of it. So as this says here, once you're on the list, any settlement agreement to get you out of the case has to contain a provision that OSHA will show up at all of your other facilities nationwide. And even if you don't settle with them under those terms, they're going to do it anyway. So once you're on this list, especially for larger companies, it's just an absolute nightmare. And then as the slide notes, you're on it for 3 years. And so we push back. And whenever I have an SVAP case, one of the first things I do when we sit down in negotiation is to say, you got to get us off this list. And sometimes it works, sometimes it doesn't, but this is just an absolute nightmare for companies because John Q. Citizen looks at this and says, oh, this company is a severe violator. Whoa, that must be really bad. Well, and pardon my French here, but the citation could be complete bullshit, and you haven't had your opportunity to prove that yet. So it's one of those guilty till proven innocent things. You can tell how I feel about it as a company counsel and how you all should feel about it, because it just, in my view, it's an abuse of the enforcement authority that the agency has. Again, no lawmakers ever came up with this. The public never got a chance to weigh in on it. It just is. And under the Biden administration, we're seeing it a lot more. It's very, very unfortunate. And to be a little bit fair, it does take a lot to get into SVEP. But all it takes is if you have the one I have now is a grain engulfment case where very tragic accident, but in our view, there wasn't anything to indicate that the company was willful. OSHA felt otherwise, and one willful allegation that we think we'll win on, resulting in a fatality, and boom, they're in this program, and the local press picks it up, and shareholders are calling the CEO 3 states away saying, what's going on here? How's this going to affect our stock? Well, all that stuff based on a program that they just kind of dreamed up. So again, end of soapbox.
Yeah, I had a feeling you'd jump in on that one. So I think it's important for you to know where OSHA's offices are. I have some funny stories about that. So especially if you're in construction, if you're working near one of the OSHA offices, you probably ought to be aware of the fact that they're looking at your job when they drive in and out of their office. And back in Chicago, I had a funny story. It was the Chicago North office, and there was some construction work within 2 blocks of this OSHA office, and there were a couple of laborers that were riding in the bucket of a front end loader down the road. The OSHA inspector saw this and stopped, showed his identification, said, I'm with OSHA. But he also said, do you realize where your job site is? And the contractor had no idea. Now, I'm not promoting to only use safe work practices when you're working near an OSHA office, but the irony is you probably ought to know where they are because they're going to be all over the place. And if there's a good time to be on top of your game, it would be when your job site is near the OSHA office. Yeah, exactly. So, for your benefit, I've included where the offices are here in Colorado. I should also point out Colorado is a federal OSHA state. There are state programs. Actually, we're surrounded by quite a few state programs, but just like Illinois was. But Colorado is a federal program. So let's move on to the inspection process itself. So first thing it starts with is the arrival of the inspector. Unless you receive a phone call or an email from OSHA on the complaint, you're going to see the inspector. So if it's a construction site, they do need to make their presence known. Typically, that's going to be at the general contractor's trailer or office. They really aren't supposed to wander onto the site collect information before they let somebody know they're there. What typically happens on a construction site when you find out OSHA's there? Well, either people, leave or they stop work. And I'm not going to argue against stopping work, because if there's something not happening, you can't be cited for what you're not doing. Would you?
Yes, with some. So, say for example, there's an excavation that is found to be ultimately non-compliant. The fact that you pull people out of the excavation when OSHA shows up isn't really going to help you, because you'll have to admit that they were in there prior. But yes, to the extent that a scaffold that they didn't see upon entry has no guardrails on it, but no one's on it, no exposure.
Right.
So,
how would that work on a Saturday, with them doing rounds on Saturdays if management's not there and they're supposed to come in and check in? They have to come back on Monday, or?
Well,
that's a great question. So the question is, how does this work on inspections, whether it's on a weekend or any time when management isn't there? What OSHA's philosophy is that someone who is on site is in charge of the site. I don't care if it's an hourly employee who's been there 2 weeks. If there's two people, we're going to find out which one of them has the authority, and that is management. Now, we push back on that, and the reason we do is we say, look, if we have guys out on the weekend, and on Friday, before they go home, we say, you have to be using your fall protection up at heights. Okay, yes, we're going to do that. Sign off that you're going to do that. Yes, we're going to do that. They go out and they don't do it. And we'll get into this on the misconduct defense later, but we maintain that that's not our fault. We did everything we could. But OSHA's philosophy is that, hey, somebody has to be in charge of the site who's on the site. That makes you the company responsible. We have those fights all the time.
So, and we'll get into this part a little bit later too, but generally speaking, they will give you an hour for somebody responsible for that at your company to show up to the job site. You do have the ability to ask them to wait while you contact somebody that will come out and handle the inspection.
That's why you have to have your folks trained. And then, hey, if you're working without your foreman there or a supervisor there, if OSHA shows up, call XYZ.
Honestly, I would say the biggest weakness I've seen in companies with respect to OSHA inspections is not being prepared for it. In fact, I actually, kind of a funny story, I had a client that was so concerned about it, they asked if I would go to their facility, pretend to be a compliance officer. I said, I'm not going to do any impersonation. But they said, please show up. We're not going to tell our people. Tell them you're there with OSHA. And they had actually gone through some of this with their employees. So they asked me to patiently wait in the conference room. But the funny part of the story is the conference room had a big picture window into the operation. So they had me wait in this room. And they said, would you please wait while we gather our management team? And I was in the conference room, and I could actually honestly observe multiple violations going on. Somebody on a forklift that didn't have a seatbelt on. Yes, that's a violation. So they had everything right, except they put me in the wrong room, which gave me the right to collect that evidence. Yep. So whenever OSHA arrives, don't read them the riot act. Bad time to cop an attitude. I think Pat and I would agree that some of the behavior that we see from OSHA, I would consider to be not as professional as I'd like, but it's not a good time for you to cop an attitude. Be polite, be professional. Don't give in. Know your rights, which is one of the reasons why we're doing this workshop. The OSHA inspector, COSHO, CSHO, should show their credentials. They should have government identification proving that they're with OSHA. And there have been, was there even recently here somebody who was impersonating?
I don't know about here. I'm familiar with one story where a guy, I used to say, who would pretend to be an OSHA compliance officer? Well, there was one case back east, New York, I think, where somebody did that, said, hey, I'm with OSHA, here's a violation, write a check and make it out to me. And get on the way with it. And so, yeah, I asked him, and it's funny, the OSHA, they're very bureaucratic, as you can imagine. I have compliance officers that I've worked with for more than 10 years. They still show me their credentials. And so it seems kind of like a formality, but make them do it. Especially now we're getting a lot of new COSHAs. I don't know what you're seeing, Gary, but a lot of new faces. And yet, just to make sure, let me see that.
Yeah, and you have the right. If they don't have identification, you have the right to say, I'm not going to allow you in here. I don't know you're with OSHA.
Yeah. Now, what I would do in that situation is pick up the phone and call the area director and say, do you have a compliance officer named XYZ? And maybe look at their driver's license. So you don't want to completely kick them off if you can avoid it.
So probably one of the most important questions that you should be asking, they should offer it. They should offer the reason why they're there. But if they don't, you should ask the compliance officer, why are you here? If it's a complaint, they should tell you. If it's a complaint, they should show you a copy of the complaint. It won't have the name of the person who filed the complaint for retaliatory purposes, but they should show you a copy of the complaint.
And who can take a stab as to why that's important? Because it's going to limit the scope of the inspection. If the complaint is about one machine over here that's not guarded, that's all we're going to let them see.
Yeah. Another funny story related to that. So there was a complaint about an unguarded punch press in a manufacturing operation. This is a true story. I wasn't personally involved, but I heard the story. And the company apparently had been well-versed in OSHA inspections, so they asked the compliance officer to wait. And during the 1 hour that they asked the compliance officer to wait, what they had done was they had built a plywood tunnel from the visitor's door to the punch press that was involved in the complaint, which, from a plain view hazard perspective, probably wasn't a bad idea, although there was some game playing being involved. And after they had constructed the plywood tunnel, they invited the compliance officer to pass through the door, and the plywood tunnel took them specifically back to this machine. I don't recall if there was a violation with the machine, but clever, but they knew they were getting
Got a reason suspicion.
gamed. They may ask, you should ask for an opening conference. If they don't offer an opening conference, and I don't know what your experience is, Pat, but they don't label what they're doing sometimes. They'll hold the opening conference, but not tell you.
Yeah. And it's, especially on a construction site, is you want to talk to the compliance officer about whether they want to do openings separately with companies, or more often than not, they do it as, okay, get everybody in here. Because, and we'll talk, I don't want to get too much into the weeds, but the reason that all the companies need to be involved is because the OSHA Act gives every employer who's being inspected the right to participate in the walk-around inspection. And I'll talk a little bit later about what the failure of that might result in. But yes, they don't always call it an opening conference, but once they start asking, okay, who's in charge here? What are you doing here? What's this operation all about? That's an opening conference. And that's where you need to be asking the questions that Gary has talked about.
They can ask for a union representative if there is a union representative to participate in the inspection. And at that point, as Pat mentioned before, you should agree on the scope of the inspection. And ultimately, the inspection should be limited to the complaint, with the notable exception of plain view hazards. So, believe it or not, they're looking for falls. They're looking for struck by hazards in construction. And if there's a fall complaint or whatever the nature of the complaint is, they're supposed to limit that. But if on the way to investigate that, there's an unlabeled can of gasoline, that's a plain view hazard. It could be cited.
And another potential exception is if they're there on an emphasis program. I had one this past summer that they showed up on a complaint, very limited complaint, but they say, hey, we have a green handling national emphasis program. We want to do a wall-to-wall inspection. Now, again, you can still make them get a warrant, but all they're going to do is hold up the emphasis program, and the judge is going to okay it. So what I did there is you call the area office, you get them to kind of limit it reasonably, gives your guys time to clean up the machine shop and do whatever they need to do. But that's another potential exception. But yeah, plain view is the one you see more often.
When OSHA arrives, you do have the right to ask the compliance officer to wait while you assemble a team. Be polite. Have them wait in the lobby. You can offer them water, coffee, Probably not a good idea to offer them $1,000. Could be a problem.
Potentially. Or a drink.
Or a drink. There you go. Obviously, this goes without saying, is you're going to want to accompany the compliance officer at all times. Believe it or not, I'm familiar with stories where the employer said, well, I've got nothing to hide. Just go out in the plant, take a look around, tell me what you find. Not a good idea. There's actually damage control that you can do while you're with the compliance officer. If it's quick fixes, you might even get a credit. More likely than not, if you take care of an issue, an employee's not wearing safety glasses. Happens all the time. Now, we're going to talk about the misconduct defense that can help you with that. But if somebody's not wearing safety glasses, just point at your face. The employee will put the glasses on. Compliance officer might make a note of that. But when the citations are issued, if it was just one minor event that was addressed immediately, you may never see that on the citations you receive.
One important thing on that, and I've run into it a few times, some compliance officers, not many, will, on the walk around with something in plain view, they will say things like, well, that cord doesn't have strain relief. Don't you think that's a violation of 1910, whatever? What you do with that is you say, thanks for pointing that out. We'll look into it. And then you pull somebody aside and say, would you get that out of here? But don't admit, oh yeah, that's a violation. I mean, because then that tells you they're going to write the ticket. So most compliance officers are good about this stuff. Kind of low-hanging fruit, plain view stuff. Yeah, just fix it right away. Don't worry if you get dinged on it. More often than not, you won't.
You know, it's probably a good point, good time to point out the fact that in my career, I would tell you that the majority of compliance officers I've worked with have been reasonable people. Yeah. The problem is you need to protect yourself from those that aren't. So the things we're talking about, first of all, you're here today. You care about your people. You care about your safety program. You care about being inspected by OSHA. So you're a step ahead of the competition. But just like any other walk of life, there are compliance officers out there that shouldn't be in the business they're doing. And one of the problems in the government, quite honestly, is it's difficult to get rid of people.
Yep.
So if you have, and I really don't have this in the slides, but at times you could have an unreasonable compliance officer. And my experience has been contacting the area director to express your concerns is something that you should consider doing, because generally they've probably heard from other employers before.
Yeah, and I've done that before. It's not something I like to do, because when you're dealing with the same area directors over and over, you can't do that on every inspection without losing your credibility. But yeah, if a compliance officer is either getting too abusive or just not playing by their rules, I'll pick up the phone.
Yeah, and in one situation that I was directly involved in, the compliance officer was actually telling the laborers, union situation, that the operators don't care about the laborers. He was actually creating a labor dispute on the job site in the way he was handling himself. Take notes, take photos, take notes. I would suggest, if you're handling the inspection, have another person there that can write things down. You can focus on the inspection, the questions that are being asked. I'm just not a good note taker, which is why maybe I want somebody with me to take notes. But I think it would be a good idea to have two people, one to take notes, the other one to focus on the questions and what's being answered. Take pictures from multiple angles. Pictures are really funny. Pictures should also include measurements. Measurements are critical. Especially, as Pat mentioned, there's a huge emphasis on trenching and cave-in. And a 5-foot 1-inch trench that's not protected is a problem. 5-foot 1/4 inch if you wanted to really get picky. So measurements and photographs are hugely important.
And can I jump one thing there? And this doesn't come up a lot, but I have had it. And this is kind of a very lawyer concern. Oftentimes the compliance officer, it might just be you and her on the walk around. And if she's going to take a measurement and she says, well, will you hold my measuring stick for me? Never do that. And the practical reason is, if we down the road dispute their measurement, you're a witness. And so we have to call you as an adverse witness, saying you might have been holding the measuring stick wrong. Or so just never, they're there to do their inspection. You can take your own side-by-side measurement either while you're there or later, but never assist them physically in the inspection because it creates trouble for your lawyers down the road.
And we did talk about this briefly, but if you're being inspected for a fall protection violation based on a complaint, and the compliance officer says, well, I would like to take a look at your safety data sheets. That's outside the scope of the inspection. You do have the right to say, hey, look, that's kind of has nothing to do with fall protection. Really would prefer that we stick to the scope of the inspection.
Yes, but there are some categories of documents. Oh, turning on would be up. All right. There are some categories of documents that you have to provide them. Your HAZCOM program is one. That's by regulation. So you should know what those are, like your OSHA 300s. But yes, absolutely. If they're asking for, if it's a fall protection complaint, what they sometimes will do is say, give me your safety program. Well, no, here's the table of contents. What do you want to see? And if they're asking for confined space and they're there on a fall, no, you don't get to see that.
The one thing you should be aware of is OSHA has the right to speak with employees, interview employees, without anyone else being present. The one exception to that would be a foreman or supervisor. They're considered part of the management team. I'll let Pat comment on this, but you would have the choice of either being present while your supervisor or foreman were answering questions to OSHA, or you may decide to let them speak with them privately.
Yeah, and of all, this is one of the hardest decisions you have to make in an OSHA case, especially if it's a big one, because the line between management and non-management is not always very clear. As I alluded to earlier, OSHA takes the position that whoever has the ultimate authority physically on that site can be considered management. So, and where you usually see it is at the foreman level. You know, if you have a superintendent, there's really no dispute that that's management. But foreman maybe is hourly, but does control the work that goes on at the site. If you decide, okay, I'm going to designate that person as management, that gets me to be in the interview because, as Gary said, managers speak for the company. What they say can bind the company. So me as the company's attorney, I get to be there. The downside of designating a foreman as management is you're stuck with whatever they say in terms of admission. So if the foreman says, yeah, I knew that was screwed up and I didn't do anything to correct it, hopefully they don't say that, then you're stuck with that. That is a management admission. The risk of not designating a foreman as a manager is you don't get to be in the OSHA interview, hear what they say. And I got burned on this once, and I'll never make the same mistake again. I didn't designate a foreman as management. We get the citations, and they're all based on what the foreman said to OSHA. And I squawked. I said, that's not a management admission. That foreman is not management. I told you that foreman is not management. OSHA said, we disagree. We think they had enough authority over the work site to bind the company. So when in doubt, over-designate somebody as management. I think that's the better way to go. But there's a lot of gray area there. It's not black and white.
You know, and something else, because a lot of issues come from the interviews with employees. I would encourage you, as part of preparing for the OSHA inspection, to have a talk with all employees. And probably the most important thing you could communicate to your employees is to be honest. There is a huge misconception, I think, in the employment community where employees actually believe they could be held responsible by the agency. They don't know. So if you have an employee who is supposed to be using PPE and OSHA asks, have you been trained how to use or when to use the PPE? If that employee thinks they might be personally liable, how do you think they might answer? No. So if you encourage your employee to be honest when they're asked questions, and you let the employee know, hey, look, if OSHA ever visits our job site, you are not personally responsible or liable. We are. as your employer, there's a better chance that they might be honest, especially, and I would say this because you're all here, because you try to do the best you can for your employees. So as long as you're making a good faith effort to provide for the health and safety of your employees, tell them to be honest. But there will be some follow-up questions. Has your employee trained and instructed you to use safety glasses? And if the employee says yes, but they're not wearing them, OSHA may ask, well, does your employer ever have people come around the work site to make sure that you are wearing safety glasses? And if you have people that inspect, hopefully, periodically, hopefully your employee says, well, yeah, we have the safety guy, that bald guy who needs to retire, Gary. He comes out to the job site and he takes a look around, and if we're not doing things, he'll tell us that we need to wear the safety equipment. There could be another question of the employee, and that would be, well, if you're not wearing PPE and your company comes around to inspect, does the company hold you accountable for not wearing the PPE? And wouldn't it be nice if the employee said, well, yeah, I knew somebody who was disciplined for not wearing safety glasses last week. That's actually a good thing.
Yeah. Couple things here. As Gary mentioned, I think more than half of all training citations I've ever defended come from what an employee says in their confidential interview with OSHA. Because we can't be there, we can't correct it, we can't, these employees say they are trained. You could have paperwork up to here to prove otherwise. But like Gary said, they're nervous, they want to deflect their own blame. So absolutely tell them, hey, if you like working, you tell the truth, and yeah, we have nothing to hide, all that good stuff. So yeah, that becomes an issue there. But yeah, it's on the misconduct type of thing. Oh, and we'll talk more about it, how it affects a citation later. But OSHA does like to hear that you take care of unsafe workers. A lot of times employers think, oh, I don't want to fire somebody for safety violations because OSHA. I mean, I've had OSHA come to me before and say, why is this person still working for you? You should, that's a bad apple. You need to get rid of them. So yeah, the more your workers are willing to say, yeah, they really crack down on us here if we don't follow the rules, that helps the misconduct defense, which we'll get to here in a little bit.
So on that note, that's the wild card, is that you should understand OSHA is going to speak with your frontline workers without you being present. And I'm curious, Pat, what your opinion is on carefully debriefing an employee following that interview.
There are different schools of thought here, and the concern is retaliation. They do have a right to a private interview. On the front end, I know lawyers and other practitioners in the area who are comfortable telling non-management employees, hey, keep your answers short, don't speculate, listen to all that stuff that I would prepare a management person for. I tend to not do that, and I don't think that's a good practice, because a good compliance officer in that interview will say, who have you talked to before this? Well, I talked to Pat. Well, what did Pat tell you? He told me to keep my answers short. That's not going to look very good. So the only thing I advise you telling your employees is tell the truth. Now, afterward, it's a little bit different. The employees have the absolute right not to tell you anything about what they told OSHA. So it's okay to go to them and say, hey, I would like to know what you told OSHA. You do not have to tell me. But if you want to, tell me what the conversation included. And once you have that, you can do that. Second thing where employers get tripped up sometimes on the debrief is you are still entitled as the employer to the underlying information. So say they have an employee who witnessed a fall protection issue. They get in there, OSHA's going to ask them what you saw, heard, all that good stuff. When you talk to the employee, you can say, I don't want to know what you told OSHA, but will you tell me what you saw, heard? I mean, you're still entitled to that underlying information, and the employee will have to talk to you. But in terms of debrief, if the employee says, or even expresses some hesitancy about wanting to talk to you, just drop it, because you want to avoid retaliation stuff, because 2 weeks from now, you might be wanting to fire this person for completely legitimate reasons. And then they're going to say, well, it's because they made me tell them what I told OSHA, blah, blah, blah. So I don't push the debriefs very hard.
Yeah, you do need to be careful. Yes, ma'am.
So real quick question, do you find that in those debrief conversations that it is to avoid that feeling of retaliation or potential retaliation, it's better to have like either an HR person or the CB manager having that conversation with employees as opposed to somebody directly in a supervisory role or operation?
Yeah, that's a great point. And the answer is yes. And I always recommend more than one person. So you have a witness to say, you know, the HR person said, you don't have to tell us. And it's documented and all that. So I find that more often than not, employees are really on your side. And so most of the time, hey, do you mind telling me what OSHA said? You don't have to. Yeah, they'll talk about it. But yeah, that's a good point, especially if there's any hesitancy there, or I might need to talk to the union foreman or a coworker about it. That's at the point I've had that happen where I tell a client, just drop it. I mean, we'll get OSHA's file down the road eventually, and it's not that important. You don't want to create an employment issue where none existed.
We touched on this. Don't allow the compliance officer to be disruptive. I mean, it's rare, but it has happened, as I pointed out in a few examples. Expect that the compliance officer may return to the job site. There is no advance notice of an OSHA inspection. Once it's started, then return visits can be coordinated, especially if there's going to be things like industrial hygiene work that needs to happen. So you'll never know that they're coming for the first visit. After that, there will be communication about future visits. Some of these things can drag on for a long time.
Yep. One note too on the disruption issue, and this comes up a lot. If OSHA ever asks you to start up a machine so they can see how it works, or start doing something that you otherwise aren't doing, say no. So you can go look at that machine, but if it's unguarded, for example, and you put somebody in there operating it, whether you did it at the COSHA's request or not, then you're looking at a willful violation. So if they say, well, I want to see how this machine works and how it runs, just say, I can explain it to you, but we're not going to do that. Those are things where nothing good can happen.
Great point. It was not during an OSHA inspection, but I am aware of a situation where an unguarded machine resulted in amputation, and when they tried to replicate what happened, second amputation. So fortunately, there wasn't a third. So when the inspection is done, there should be something called a closing conference. My experience is sometimes it's not delineated, and it really, in my opinion, never happened. But ultimately, there should be a closing conference where the compliance officer identifies potential violations. You may not get citations for all of them that they list, but there really should be a closing conference.
Yeah, and this is another thing that really bothers me. It's not a statutory requirement, it's not a regulatory requirement, but it's something that OSHA sets up as an agency as a matter of good faith with the regulated community, where they sit down with you, they say, this is what we found, these are the citations we're going to propose, tell us where to send them, and that used to happen as a matter of routine, but what I'm seeing lately, and I'll tell another war story here on that SVEP case I was telling you about, it's in Nebraska. We get a call, they didn't even contact me, they contacted the site general manager saying, hey, I have citations for you, can you meet me at a gas station halfway? And the general manager calls me and says, what's going on? I call the OSHA area office in Omaha and say, we never got a closing conference here. And what they told me is, we don't do closing conferences anymore because they've gotten to be too confrontational. And I said, well, I hope, I'm here in Denver on the phone and I'm an attorney. You don't think we're going to get into a fist fight over this somehow, right? And why can't you tell me what we're being cited for? He just said, we're not going to do it. So the compliance officer goes out, meets my client in the middle of nowhere in Nebraska, and hands us a citation for over $500,000 with multiple willfuls. And that just set me and my client. That's just not the way they should be doing things. You need to be knowing what you can expect. You need to let them know where to send the citations. You need to know what your rights are. So I really push for closing conferences because I just think it's poor form when they don't do it.
It is, and it's an opportunity for you to show good faith.
Right.
And good faith should count for a lot with the agency. Was that near the end of the 6-month mark when they hand delivered those?
It was 8 days before.
Yeah. So familiar, they have 6 months from the date the inspection starts to issue citations. And I'm familiar with a confined space inspection where they were hand delivered, I believe, the day before the 6-month rolled out. No time to even send it certified mail.
Yeah. Yeah.
So the closing conference is really important because the one thing that I probably should have emphasized more, you're trying the best you can, you're trying to develop a relationship with an agency that has some control over your business. And it's best to develop a good working relationship with them. You're here for a reason. There's people that didn't come today that really don't care. You're not them. So this closing conference gives you an opportunity to say, here are the things we're doing. Here are the things we don't think. We think there's no foundation for the citation. You have an opportunity to push back on anything that they discuss at that closing conference. And Pat, I don't know about you, but ongoing communication throughout this process, I think, is hugely important.
Couple of things there. I mean, even though OSHA inspections can get emotional, especially if there's injury and death involved, you need to demand courtesy of the agency just as much as they would demand courtesy and respect from you. So it goes both ways, and usually it's not a problem. But on the closing conference, and I had this just yesterday, I was telling Gary about this before, I had a case where they do a proper closing conference, which happened yesterday, and they said, hey, we're going to cite you for X, Y, and Z, and for failing to report a fatality. And I said, what do you mean failing to report a fatality? They said, well, this employee was hospitalized due to an accident. My client reported it within 24 hours. This employee subsequently passed away a few days later, and my client did not report the fact that he died to the agency. Probably should have, but I thought, I scratched my head, did a quick search of OSHA interpretation letters, and found out that there's an interpretation letter out there saying you don't have to re-report that. As long as you report it the first time, the subsequent fatality doesn't need to be reported. Sent that right away to OSHA. Hey, you look at what your letter of interpretation says. They say, oh, okay. And they pull the citation. That's what a closing conference is for. So they don't want to write bad paper most of the time. So again, just good communication goes a long, long way. It was respectful. I didn't point out, hey, you're dumb. You didn't look at your own interpretation letters. Just very politely say, look, this is incorrect. Will you please pull it? Yes, Pat, we will. Thanks for letting us know. Done. I mean, establishing a good relationship is never a bad idea if you can.
And you know what? They've seen companies that are the opposite of you. They know what bad is. So your opportunity to stand out from them is to your benefit for sure. Certainly, you have an opportunity to point out the strengths in your safety program. They know what these things are. If your experience modification rating is a 0.74, brag about that. You're 26% better than your average peer. So things that work in your benefit, favorable incident rates. If you track your incident rates and you're better than your peer group, these are things that you should brag about in order to establish the good faith that you want to with that agency. Involvement of your employees in the safety program. They're big about this. You may not have a safety committee, but there's other ways to involve your employees. If you have a program where employees can report near misses or report hazards that are taken care of, those are good opportunities to bring up the programs that pull your employees into the safety program as an active participant. Okay, so things that are important in your safety program, written policies and procedures. If you've got rules, they need to be in writing. Documented evidence of employee training, documented evidence of safety observations and audits, and documented evidence of disciplinary action for safety violations. Those 4 things are going to become important for the carrot that I'm dangling for the end of the presentation.
Yeah, and just a lot of employers are hesitant to document their audits and corrective actions because they think it's giving OSHA a paper trail down the road to write citations. OSHA has a policy, and they mostly follow it, that if you're doing regular compliance audits and you correct noted violations as soon as you can, that they are not going to use that against you in an enforcement action. And for the most part, in fact, they're not even supposed to ask for it under their own policies. And for the most part, they follow that. So never be afraid to have documented corrected actions. Now, what you don't want is the observation without the documented corrected action. If here's an unguarded machine, here's a picture of it guarded. Keep that stuff, because it does show OSHA down the road that, wow, they noticed it and it was fixed immediately, and this is a good actor, and all those sorts of things. Absolutely right. Document as much as you can. Plus, it's a proof issue, right? Well, we train all of our employees on that. Well, show me. Well, just take my word for it. We do. Even if you're right, and you do, nothing beats a good documented response.
Yeah, and to Pat's point, the reason why you're doing safety audits isn't to document perfection. It's to identify potential issues that are then taken care of. So showing the compliance officer or an area director 3 years of inspections in which nothing was identified as needing, they're real world.
Red flag.
They're like, well, when we went to the job, we found 7 hazards, but you've got 3 years of looking at job sites with no violations. I guess you're not looking hard enough.
And some of them are hard. I mean, the low-hanging fruit is easy. The machine that's not guarded, or the cord with bad strain relief. Some of them are more complicated. For example, you might be doing an audit of your lotto policy or your confined space program, and there are deficiencies there that are going to take a long time to fix. As long as you're taking measured steps and reasonable steps, that will still keep you out of, every now and then OSHA will say, well, this is willful because you identified the problem and you haven't fixed it yet. As long as you're taking reasonable steps that are documented, you're probably going to be okay. So just don't do your audits and your corrective action and your documentation with an eye toward what OSHA is going to ding you for down the road. Do it because you're correcting it, you're keeping your folks safe, and it's a good practice. And it won't come back to bite you in the end. Unless you don't do the corrective action.
Right. OSHA will request information. They're going to want to know they're going to want to know the number of employees that work for the company. The reason they want to know that is that number is used to adjust the amount of the penalty. If you have a lot of employees, they expect you're going to have more resources. The discount isn't as great. We've got a slide showing that. I'm not going to dwell on that, but the number of employees is used to adjust the penalty amount. They're going to want to know your federal employee identification number, office address, and phone number. They may request, probably likely they will request, additional information, and here's the list. OSHA 300 and 300A, written safety programs, training records, safety audit, and disciplinary action. Funny, there's a thread going through here. You notice those things come up so many times? Believe it or not, when they ask for those things can work in your favor if you have them, which we're going to get to. I'm keeping the T's. For construction work, they often ask for contracts, because contracts will identify, in some cases, who's responsible for certain type of corrective action when it comes to safety.
Yeah, a couple things on document requests that I want you to keep in mind. One is the procedure here is in our favor. If they give you a document request, there is nothing requiring you, except for the 300 logs and HAZCOM, that you're not under any obligation. If you go back to them and say, I'm not giving you, except for the 300s, which I have to give you, I'm not giving you any of this, their remedy is to issue you a subpoena. Once you get that subpoena, you can still say, I'm still not giving it to you. Then their remedy, and again, I don't recommend this, then their remedy is to go to federal district court to enforce the subpoena. So the reason I bring that up is because we have a lot of room for a little bit of pushback here. Written safety programs. Okay, I'm going to give you the table of contents. You tell me what you want out of it. I'm not going to give you confined space because this is a fall protection inspection. We have that pushback. On the contracts issue, keep in mind, anything you give OSHA down the road is subject to a Freedom of Information Act request. So if you're working for a large GC and you give OSHA the contract you have with them, and their competitors start asking for it through a FOIA request, they're not going to take kindly to that. So what you can do on things like contracts is just give them the portion that deals with safety. Scratch out anything else that you wouldn't want their competitor seeing or your competitor seeing. And you can designate it as a trade secret. It's not really a trade secret, but That provision of the act allows employers to designate things as trade secret, which keeps it out of a FOIA request down the road. More often than not, OSHA doesn't care whether you designate something as a trade secret or not, but just be very, very careful about what you give the agency, because unions can get it, competitors can get it, anyone can get it down the road.
If for whatever reason you need more time to collect this, I'm familiar with, you just communicate with the agency. I'm going to need 3 more days to get this to you. They'll work with you.
Never say no to that.
There's special circumstances with some OSHA inspections. Most of them involve compliance, safety, and health officers. They have 2 different types of compliance officers. Again, I'll defer to Pat for this area, but typically they have compliance officers that specialize in construction and compliance officers that specialize in everything else. And then there's a subset of industrial hygienists that would be able to do work in both construction and general industry. If you're in a situation where OSHA wants to do some exposure monitoring, you do have the right to coordinate your own monitoring to be done side by side. So they're going to have to work with you. If you need to hire an outside firm, they'll coordinate with you to make sure that the sampling, duplicative sampling, is done and coordinated on the same.
And that's important for you all in construction, especially with respect to silica. So what OSHA does is when they collect their samples, they send it to their lab in Salt Lake City, which is a joke compared to what a large GC will be able to hire in terms of getting results. So you want that side by side, and if we have to fight down the road over results, we can do so. Remember earlier when I said you never want to start up an operation just because OSHA is asking you to do it? That comes up when it comes to sampling. So if you're at a construction site where sawing is going on all the time and there's dust everywhere, they come back and want to do their sampling, that's not usually a problem. But say, and I've had this situation come up, I had a case where some slab sawing was done. An employee complained that the levels were too high. OSHA wanted to come in and do testing, but we were all done with the slab sawing. And there was nothing else going on site that was kicking up any silica. So they said, well, bring out the saws and we're going to get a piece of concrete and I want you to cut it for us. And we're going to take our samples. And I said, no, we're not doing that. And they didn't. And, they couldn't cite us because they didn't have the numbers. So if it's part of your normal operation and they come by, yes, in good faith, you want to work with them, but you never have to recreate something that already happened just so they can get their numbers.
Interesting. Yeah, I'm going to chalk that one up as hadn't heard of that one before.
Yeah.
Okay. So, when the inspection's over, the whole process is not over. It takes a while for citations to be issued. From the date the inspection starts, the agency has 6 months to get the citations, if any, to you. So I guess what I'm suggesting is there's a lot of things that can be done in between. First of all, if a compliance officer identified things that need to be addressed, take care of those, correct them. Take photographs. If things needed to be purchased, keep copies of purchase orders, and get this information to the compliance officer as soon as possible. I think I had this on a slide coming forward, but I would offer to go to the area office to sit down with the compliance officer. It's a show of good faith. Show up in person and say, I want to make sure I cover these things with you. Here's how we took care of that issue that you identified. You're basically taking the time to establish good faith, because not everybody does that.
Right. That's good practice.
I would argue, based on my experience, that good faith efforts result in fewer citations and potentially more good faith applied on any penalties that are issued.
Yeah. And fall on your sword if you have to. I had one case where I screwed up and gave my client the wrong advice on a timing issue. And OSHA identified it. I went to them and said, hey, I've worked with you for years. I screwed this one up. Don't please. And they didn't cite it. And so you as employers, if you act in good faith, they will, not all the time, but they will reciprocate. As long as they know you're above board and you're given that effort, they'll be reasonable.
And if you believe something was not right, argue against it. obviously evidence is going to help you, but if you believe something was not correctly cited, then you need to present evidence and argue against it. And what I'm talking about now are activities that happen before the citations are issued. It's a whole lot easier, and Pat, I defer to you on this as well. It's a whole lot easier to make a citation go away before it's issued.
Absolutely. And there's some practical reasons why you want to do that too. As we mentioned earlier, all this is public. So if you're cited with a serious violation that you disagree with, it may take you weeks or months to either persuade OSHA to pull it, and we'll get into the litigation process here in a minute. It may take a long time for that to get pulled off the record. In the meantime, you're bidding for work, and you have to represent to potential customers that you have been cited for a serious violation. Yeah, we're contesting it and we're fighting it, but it's still there. So if you can, kind of like my story earlier on the reporting thing that I had yesterday, if you can head it off at the pass before the citations are issued, it didn't happen. But once they're issued, then you're in a whole different ball of wax.
I mean, not that you couldn't get them deleted. It's going to be a whole lot more difficult.
Yeah.
Which is the point I'm making here. So OSHA inspections in construction, I mean, you know, any one of us who are in construction can go out and find all kinds of problems. Here's a bad extension cord. So how many violations exist with that extension cord? This gets interesting because of the construction standards, possibly 4. The cord itself, then there's a standard that requires contractors to develop programs. It's in the general requirements section. Do you have a safety program? No, sorry, sure don't have a safety program. Well, that's citation number 2. Citation number 3 requires frequent and regular inspections by a competent person. Citation 4 requires contractors to train employees. So they ask the employee, did you know this? Did your employer train you that this is a hazard? This cord is bad. No, sure didn't get any training.
And I know we're going to get into multi-employer here in a little bit, but this is the one that OSHA is using in construction in every inspection now. When something happens, say somebody falls off a scaffold that wasn't properly protected, they're going to go after the GC, not necessarily for the failure to have the fall protection, but for the failure to do the regular and frequent inspection. This standard has been around since 1970, and I just started seeing it being cited within the past few years. This is their catch-all for when something goes bad, it has to be because you didn't do your regular and frequent inspections. And there's a lot of good law on employer side about that one. You know, it doesn't have to be, it kind of depends on the size of the project. It doesn't necessarily have to be daily, doesn't have to be documented, although it should. But this is just what they use as a catch-all when they can't think of anything else. So be really aware of that.
Just a word to everybody. I think we're going to run a little bit longer. So if you're able to stay, we certainly would appreciate it. If you have to leave, I think we probably got another 20, 30 minutes left in us. So what do we have this staying at? 2 hours?
It's 3.
Oh, we got plenty of time. We got plenty of time. Note to self, learn how long the seminar was scheduled for. I just talk. It's a disease that all safety people have. We talk. So anyway, one violation with the bad electric cord is 4 separate citations. So you start doing the math, that could be kind of costly. If you're a big contractor that didn't earn any of the discounts, you're looking at, you know, $60,000 for a bad electric cord potentially if they cite all of those.
And this is where, can you go back to that slide? This is where good faith comes in. If you have been cooperative during the inspection and you've asserted your rights, but you've still been polite, you've worked with them, you go to the area office, you show them all your programs, this is where they'll what they call group them. So they don't have to, but you might end up with just a $15,000 fine. They won't issue any penalties for the others, or they'll group them. If you fight them at every turn and are rude, and these are human beings, keep in mind, they can do this, and they will if they want to. But if you work with them and you're in good faith and all that, that's the opportunity to kind of whittle these down. But yeah, you're absolutely right. I have plenty of cases where a client comes to me and shows me this, and I like to think that, God, I've been involved, I would have made it a little bit smoother and nicer, and maybe they wouldn't see this. But it does translate. I mean, good behavior translates into real dollars.
So Pat referenced what's called the multi-employer worksite doctrine, and I'll explain how this works. But on a construction site where multiple trades are present, OSHA can issue a citation to the exposing employer. If your employee is exposed to a hazard at a job site, it could be multiple subcontractors. They likely will receive the citation. Typically, it's most importantly the exposing employer, but they can also cite the creating employer. And I'll give you an example in a minute. Sometimes contractors are hired to correct hazards, like a carpenter contractor would be hired to frequently inspect common guardrails throughout the facility. And if they haven't done their inspection and correction, even though their employee may not have been there at the time the inspection was conducted, they could receive a citation. And the controlling employer. This is the general contractor or construction manager who has an active presence on the site. So the example is a stair railing is removed on a large construction project on the stairs by a mechanical contractor to get equipment up and down the stairs. So a citation goes to the mechanical contractor for removing that protection and not reinstalling it. The carpenter contractor failed to inspect and see the guardrail missing. Even though they didn't have an employee exposed, they could get the citation. And then all the contractor's employees, and there have been some cases like this, all the contractor's employees who were exposed to that hazard receive a citation, as well as the general contractor, because their job is to oversee the construction site. Any,
I could talk an hour on controlling employers where we have to fight. Okay, you're not going to argue that you're not the exposing employer. Your employee was there. The correcting that's you're not going to dispute that contractually. You're supposed to correct it. We argue a lot about whether a GC, for example, or a construction management firm is a controlling employer. In most cases, they are. But B, what are your obligations? So if and OSHA has this is all written down, and they give good examples that they never follow. But they give examples. As a GC, as a controlling employer, your obligations to the employees there are less than the exposing employer. And that makes sense. If you're the GC, you don't need to be looking at every single issue that your subs are dealing with. You have a general overall responsibility. And the way that they're supposed to look at it is, did the controlling employer do what is reasonable under the circumstances? Unfortunately, what OSHA does is when something goes wrong, they say, well, by definition, somebody fell, so you were not acting reasonably. Even though you could be on a huge construction site that you walk twice a day, and then 30 minutes after you leave, some terrible accident happens that you could never have foreseen or corrected. Well, you're the GC, so you're responsible. They use it, this is a legal term, they use it as what we call strict liability, which means it doesn't matter how culpable you are or how responsible you are, we're going to ding you for it. And those are the fights we have with OSHA on controlling employer, because it's not strict liability. It's not, you don't have the same level of responsibility that your subs do to your own employees. Question should be, did you act reasonably? And that's more than half of the fights I have with OSHA in construction is on controlling employer.
Yeah, that's a great point. If it's a general condition that the general contractor should be aware of, they'll probably. I was involved in a case where it was a general contractor who was cited because the automatic door, the electric door, automatic door into a Walgreens that they were building, the installer was standing on the top step of the step ladder, and they involved the general contractor through multi-employer, and we said they can't be looking at everybody as they're working.
Another good example that we see a lot is excavations. If there's an open excavation that's been there for 2 weeks, clearly isn't compliant, it's 10 feet deep, no shoring, no benching, no sloping, yeah, the GC probably should have caught that, and they can be cited under controlling employer. If it's an excavation that had just been dug by the time the compliance officer happened to be driving by, it's 5 feet 1 inch, doesn't have a trench box, that's where the controlling employer, if they get cited, is going to argue, hey, we did our inspection that morning. Our guy wasn't there when this trench was cut. There's no way we could have found this, and we acted reasonably. Yeah, and so it's fact specific, but really push back on the controlling employer stuff.
Focused inspections in construction, that this has been a program they've had for years. They're focusing on falls. Falls are responsible for 36%. I did some recent math. I think it might be a year or two old. Falls, 36% of the deaths in construction occur from falls. Pretty easy to understand why. 15% are struck by, 7% from shock, electric shock, 5% are caught between type, which is primarily excavation. So OSHA's looking at these 4 things primarily in construction. Typical violations in construction, I mean, they're legion. The picture on the right just amused me, so I had to include that. I took that early in my career.
Before OSHA was even a thing.
Graduated back in 1923. You see it. I mean, but there's an interesting point to all of this. And it has nothing to do with OSHA compliance. Do you think the employee was, obviously it's wrong, but why is the employee doing that? Why are they doing that? The reason is actually kind of noble. They're trying to get the job done. So whenever you see somebody commit a violation, their motivation is to do the job. So the next question, I think the tough question, you have to ask yourself, what are we not doing in our company that would cause the employee to engage in that behavior? It's kind of a deep question. What is it about our safety culture at the company that would cause that employee to make that decision? Now, the answer might be that you're doing everything right, and this guy is just a moron and didn't know that he should have asked for a taller ladder. But there's deeper questions. Is there a foreman here or a supervisor that actually allowed this to happen? So we look at these pictures and we laugh because we see this all the time, but it really does beg that deeper question. What do we need to change or modify in our program that makes it less likely for people to engage in these behaviors? I could just flip through pictures all day long. OSHA inspections in general industry. So we talked a little bit about construction. Let's talk about industry for those. Here's a nice one. That's a punch press. They're in the punch press. That's not in the United States, by the way. Anyway, pretty wild, huh? The training was make sure that your arm isn't in there when the machine cycles. That's the guarding system that was used. OSHA will typically enter the building where visitors enter, and probably the weakest link that I found in inspections in industry is the receptionist needs to be involved, need to be part of the plan. That's the person that OSHA says they're going to meet. Now, chances are that they'll call somebody, she'll recognize or he'll recognize that this is a government official, but I have heard horror stories where the receptionist who wasn't trained just said, well, if you need to look around the plant, you're a government official, there's the door. So that needs to be part of the planning. We talked about this. OSHA should be politely asked to wait in the lobby. So there are some obligations for general industry. We talked about multi-employer workplace. There are some obligations that what they refer to as the host employer in industry needs to be aware of. Number one, temporary workers. If you are in industry and you have temp workers and you provide day-to-day direction of the temp workers, you're the employer. You're responsible for providing those temp workers with personal protective equipment as well as training. Now, you may have in your contract with the temp agency that they'll provide the training, but if they don't, understand that you're on the hook.
Yeah, and that's one we see all the time. And so it's tough because that's why you hire temporary workers. You want trained, skilled, feeble work site. But you have to do something to verify their training. You did yes for the documentation. You shadow them for a little bit. Do you need to do something to make sure they're trained? And if not, it's your obligation to do the training. But Gary's absolutely right. The test is if you're supervising the day-to-day, for all intents and purposes for OSHA, they're your employees.
You have some other obligations. If you have contractors working in your facility, it's your obligation to inform them that you have hazardous chemicals present on the site, that you have safety data sheets, that you communicate the hazards that those subcontractors and others working in your facility that are not your employees should have access to. Lockout, tagout is huge. If you have a contractor who's working on a piece of equipment, as the host employer, you have an obligation to either lock out that piece of equipment or show them how to do it. Confined space, same thing. So it's actually even expanded a little bit. And I'm familiar with a case where somebody working on the roof fell through a skylight, and the skylight was not rated for fall protection, and the host employer ended up receiving a citation because they didn't tell the roofing contractor that the skylight was a potential fall hazard because it was not rated to stand on. So there are obligations on the part of these host employers to communicate certain hazards to others that are working in their facilities. So kind of think we've beaten this to death, but temporary workers, if you provide day-to-day direction, you're the employer. It goes on your OSHA log, which is a surprise to many people. In fact, it's difficult because not only does it go on your OSHA log, but the worst thing you could do is to put it on your OSHA log and then fail to get the number of hours worked from the temporary agency. You pay a bill, but you don't know how many hours those employees work. So if you're going to take an injury involving a temporary worker and put it on your log, make sure you call the temp agency and get the total number of hours worked by all those temps in the past previous calendar year.
And it's the same thing with reporting. So if you have a temp worker who's hospitalized or a fatality, I actually had a potential client. I did take them on because they asked this question. They said, well, this was a temp. That's not my duty to report it. It was a fatality. And so I politely declined the representation after telling them that it is their obligation. So temporary workers are your employees if you supervise them day to day for all purposes. Oh.
Which is really strange because the disconnect is one of the reasons you use a temp agency is it falls under their workers' compensation program. So here you have a situation where it's on your log. If it's a hospitalization or fatality, you have to report it, but their work comp is picking up all the payments and bills involved in that particular incident. So just understand the temp thing is a big deal if you're a host employer.
Are they on the book and all of that? They involved in any way the temp agency?
Not in my experience. In fact, I've represented temp agencies before where at a case where it was out in way eastern Colorado and a kid was run over by a bulldozer. The temp agency that provided him hired me, and I was able to say, you can't cite my guy at all. The training was the responsibility of the company that hired him, and we ended up not getting cited on that. So again, there's other issues like work comp and things that I'm not speaking to here, but for OSHA purposes, temps are your employees. Because rarely are you going to have a situation where you get a temporary worker on your location and your company is not responsible for the day-to-day operations. If the temp agency was, they wouldn't be a temp agency. They'd be a subcontractor, right? So the reason you hire temps is you want to control them. You think you're getting trained people. You avoid the work comp stuff, but just know that you're picking up, for OSHA purposes, them as an employee.
So just some pictures, violations in general industry, equipment and machinery. Anybody see what maybe would be a good idea in this situation? Maybe eye protection, but they're engineers. They never get hurt. Machine guarding, potentially. Who knows? Here's a good one. Should I leave it up a while?
Can't that last second I
Right.
Sorry.
I don't know if I told this story, but I did an OSHA 10 hour for a carpenter contractor, and unfortunately, I brought some of the Chicago sarcasm with me, and I said that when you're pounding nails, you never have to wear safety glasses because the nail goes into the material. Of course, that's wrong. Anybody who's pounded nails knows if you hit it with a glancing blow, they come flying back. And so after that, he stood up, and I was glad he stood up. He had a glass eye. I knew that from the time we started the class. This is back in the day when you did a 10-hour in one day, which was brutal. So he stood up and he goes, "Hey, I want to tell you guys, some of you know what happened to me, but many of you don't." It was a room full of 30 people. He said, "When I was an apprentice, I was pounding 16 penny nails and I hated safety glasses. We had them back then, but they were uncomfortable to wear. They fog up, and I just didn't like to wear them." And he said, I was framing, I was hitting a 16 penny nail, and I'll be damned if that thing didn't come flying back and went halfway through my eye. Then it got better. He said, my first reaction was to pull that nail out of my eye, but what he did was he dislocated the eye, so now he's holding his eye on the nail and looking at it with the one good eye that he had left. But the most remarkable thing was what he told the group. He said, and anybody who's ever worked with me since that happened has never seen me without a pair of safety glasses. And I'm thinking, pardon my French, no shit, dude, you're down to one eye. It's a hell of a time to get religion. You got one eye. So he wore a little safety monocle. No, that part I made up.
Oh, no.
Just made that up. Well, here's a gray area. Anybody? So look at the way he's reaching. Heavy bag. What is it possible somebody could raise concerns about? How about ergonomics? Yeah. They've been threatening ergo standard for a long time.
Well, there was one that was proposed. It got pulled by Congress.
That's right.
Yeah.
Someday.
I did this is another war story. Yeah, ergonomics, you don't see it as much in construction as you do in industry, but I had a case that it took about 2 years to get them solved. It was in a meat packing plant, and they went general duty. And so we got experts to, for refute their allegations. One, that there were the musculoskeletal hazards, and two, that they were common in industry, things like that. So look at ergonomics, even in construction, because I have seen it cited under general duty.
Any, aside from the citation potential of ergonomics, you're going to see it first on your work comp losses. So it's an issue that we all have to address. Unfortunately, we have to battle pre-existing conditions. Worse than that, it's difficult for us to know how a person is coming to work for us. You don't have the right to know. They have to be capable of performing the essential functions of the job. But if you hire somebody whose back is on a thread, they work for you for a day and claim a back injury, the sad reality is that that's going to be your comp claim. Moving on to the different types of OSHA violations, we have, in only a language the government could use, we have other than serious, and then we have serious. Couldn't be non-serious, it's other than serious. Repeat, failure to obey, willful, unclassified, egregious. We're going to focus on the most common would be serious and other than serious. You certainly want to avoid willful, egregious, and criminal. So other than serious, typically a paperwork type violation, not having the OSHA poster, not posting the 300A form. These are typically other than serious citations, although it's very common when negotiating with OSHA to work with them and have a serious violation recategorized or reclassified as other than serious. I would say the most common thing that you're subject to would be a serious violation. But there are criteria, and Pat, please feel free to jump in. The criteria for a serious violation to be issued is that, number one, an employee must be exposed to the hazard. Now, you might have some creative ways of how proving that didn't happen that might come back to embarrass you, but An employee must be exposed to a hazard. I think Pat came up with a great example. There's a scaffold platform. Nobody's working on it that's missing a guardrail.
The standard is it reasonably foreseeable that an employee will get into the quote-unquote zone of danger. I've had employers who want to argue, hey, this open pit here that's, well, that's a bad example. This fall hazard here, no one was really near the leading edge, but it's reasonably foreseeable that they could be. So I rarely argue lack of exposure, because unless your folks aren't anywhere near it or couldn't be anywhere near it, that's a hard one to push back on.
Yeah, one that I'm familiar with, was not personally involved in, but, safety people talk, was a trench excavation, no protection, footprints in the gravel in a rake. So nobody was in it, but somebody was in it. So good luck trying to argue that one. The hazard must be feasibly prevented, and we'll get great slide to point that out. There has to be a reasonable method of protecting from the particular hazard. And the hazard exposes the employee to threat of serious physical harm or death. So the best example, does the ladder have to be tied off at the top? Does the ladder have to be tied off or prevented from moving? Let me put it that way. The answer is yes. If you tie it off at the top, can it be tied off before you climb it? Kind of hard. You could use a bucket truck, but then wouldn't you use the bucket truck to gain access? So the point is that things like this, they can't cite. If somebody has yet to climb the ladder to secure it at the top, that they're asking somebody to do something that's impossible, can't be cited. Repeat violations, if you're issued a second violation within a 3-year period, used to be 5, now they've shortened it a bit, been a while, and it can be broadly applied. So standards, as you know, have specific numbers, but if it falls within a fall protection situation, it can be a repeat even if it's not specifically the same standard that was originally cited.
Yeah, that's correct. A couple things about repeats that you really need to watch out for. One, the 3-year look-back period is just something they say they do. There's actually a circuit court case that says OSHA is not bound by that. Repeat is not defined in the statute anywhere. OSHA just says it's our enforcement policy to look back to 3 years. But if they go beyond that, they can do that. So just word to the wise on there. Where I see repeat the most is in large companies from state to state. So I had a case years ago where there was a minor machine guarding violation in Nebraska. They got cited. They went in. They settled it quickly. It was no big deal. It was a $3,000 citation. A couple years later, out here in Colorado, somebody gets an amputation based on a similar machine guarding violation. It's repeat. Same company. Doesn't matter that it's different safety managers. Doesn't matter that it's different locations. Same company, repeat. Now, the one caveat to that is you cannot use a state OSHA violation to support a federal repeat. So, for example, if you have operations in Utah and you get cited out there as a state plan, you have the same issue here. The feds cannot go repeat on that. But we fight about repeats all the time because there's entity issues that are involved. Maybe you want to argue that, well, this is really they're related entities, but we're not the same for purposes of repeat. We fight about that. But the big one we fight about is what Gary mentioned. How similar does it have to be a repeat violation? I've actually made the argument, we ended up settling the case, but even under 212A1 in general industry, which is just the general thou shalt guard all your machines standard, I was able to raise enough differences between the machines that were involved, even though it was the same standard, to convince them that maybe they didn't want to go repeat on it. But really, and this is why when you go in to settle at the informal, and we'll talk a little bit about that, why most clients I have, protecting your OSHA record is the primary reason why you get attorneys involved, why you push things. It's not usually the money. As Gary mentioned, that can get pretty high. But what you want to do is protect your record, because once you get a repeat, then you're into the 6 figures, things like that. Another big misconception that employers have is they say, well, I went into OSHA and I got that negotiated down to an other than serious, so now I'm not on the hook for a repeat. That's not true. They can use an other than serious to form the basis of a repeat, and they do. So this is why you want to protect your OSHA record. This is why when I go in to settle things with OSHA, it's kind of like pleading out a speeding ticket to a busted taillight, right? You go in and you say, look, we were cited for a 212A1. And I'm frank with OSHA. I say, look, this is a good company. You got us on this one. We want to protect our record. We want to protect against repeat exposure. Let's move it to a training violation or something that we're not going to typically see down the road. And, we'll even take it as a serious maybe. OSHA will agree to that. You sign off on it. And then next time you get the guarding issue coming up at another facility in another state, 2 years later, you don't have to worry about that being a repeat. So repeat is usually first on my mind when I go in to settle these things.
And again, Pat mentioned this public information. So you can go on the website, the OSHA website, do an establishment search. It will list the category of citation, the amount, what it was negotiated to. It's all public record. Failure to abate, don't typically find this in construction. I've honestly never been involved in a failure to abate case. They issue a citation. You're supposed to address and correct the hazard. If you don't communicate, you don't take care of it, you could get a failure to abate.
Yeah, I've come close a couple times. Failure to obey, the reason that it's so serious is because they could issue daily penalty. So up to whatever the maximum is now. So, but it has to be done for the exact same condition. So say you got cited on this machine right here, it wasn't guarded, you pay your money, but you never fix it. That's a failure to obey. If you fix this one, but then they find that your other ones over there aren't fixed, that might be repeat, but it's not failure to abate. One other thing on failure to abate, a few years back, the solicitors here in Denver and OSHA here in Denver, they're putting language into their settlement agreements that say, because what we do oftentimes is we settle for what we call enhanced abatement terms. Okay, so you reduce this to other than serious, and in exchange, we will give you something that we don't otherwise have to give you. Enhanced training, third-party audits, things like that. OSHA is now putting language in those settlement agreements that say, if you fail to do that third-party audit or the training you agreed to, we will consider it failure to abate, which I always push back on. I've never seen them enforce it, but that's the kind of thing that keeps me up at night. So if you go in there and you ever settle one of these things for enhanced abatement, make sure it's something that you can do and that you can prove that you've done so it doesn't come back in this situation. But yeah, very, very, very rare. And they usually only come after the really bad actors on stuff like this.
Yeah, I've been told at informals that the amount of the penalty reduction they're willing to negotiate needs to be reinvested in the safety program, but I've never seen them come back and audit that. But
yeah, failure to abate inspections are really, really few and far between.
Willful violation, you want to avoid a willful. The willful is you knew but chose not to address it anyway. And I'm sure, Pat, you're going to want to talk about this. This can be broadly interpreted. If you're an excavation contractor and you have an unprotected trench, you can't say in that business, I didn't know that I needed a trench box to protect the employees. So you're expected to know, depending on the type of business you're in, what hazards you need to protect your employees from.
And this is one we fight about a lot because obviously the money's bigger and the categorization is bigger and there's criminal implications, which Gary will talk about in a second. But basically, there's a big case that came out of the D.C. Circuit a few years ago that, and this is a direct quote, it takes a lot to be willful. To be willful, like Gary said, you either have to show that the employer knew that a condition violated a standard, or had it known that, it wouldn't have cared. And that's the second prong is usually where we fight it out. If you have a guy, everyone knows where you need the trench boxes and things like that. We may argue factually, well, maybe the person didn't know how deep the excavation was or blah, blah, blah. We can argue those things. But the phrase they use is plain indifference. You have to show, because to know that the hazardous condition exists is something that OSHA needs to prove for every violation. Willful is supposed to be at least a special category that there's some evidence that this employer was so plainly indifferent to employee safety that had it known that the condition violated a standard, it just wouldn't have cared. If you can show evidence that, no, we've corrected these things in the past, yeah, we knew about this one, but our state of mind was not at that heightened level of plain indifference. That's how you push back on these days. I think that OSHA cites willful way too often, and they usually do it by saying, well, it was obvious that excavation was there and you didn't have the trench box. Okay, well, maybe our foreman wasn't there, and had the foreman known about it, he or she would have corrected it. I mean, the willfulness standard is willful should be reserved for, hey, you get in that trench and you connect that sewer line. I don't care that it's 10 feet deep, and I don't care that it's vertical walls. You get in there and do it now. That's willful. What OSHA does, I think, on most of these cases is they way overshoot it. I'm involved in many cases right now where the only thing we're fighting about is whether or not it's willful. We'll say, yeah, we didn't have the proper shoring in there, or we didn't have the proper rescue retrieval line. Yeah, we don't dispute that. But can you show that heightened state of mind that, again, pardon my French, but it's the employer didn't give a shift test. That's really what it boils down to. This is a bad actor. They don't give a shit about safety. Something happened. That's willful. It's not for your everyday run of the mill, even if the employer knows the condition is bad. Maybe, so even if you take minor steps to fix the problem, that negates willfulness. So the trench example, guys in the trench, okay, get the box in here, get the box in here. Okay, the box is at the other work site. It's going to take 10 minutes to get here. And you don't immediately pull your person out of the trench. That's something that OSHA might say is willful. The employer then says, no, we were taking steps to get the box there. Yes, maybe we should have pulled the employee out as well, but the fact that we were doing something to correct the hazard negates willfulness. So that's one of the biggest fights we have with the agency is what's willful.
Yeah, and when you get to that point of willful, then you're also dancing with criminal, especially if there's deaths. One incident in Wisconsin many years ago, underground construction, utility installation, I don't remember, 12 foot deep, whatever it was, unprotected, 2 laborers in the trench. Initial cave-in happened. The workers got out of the trench. The foreman on the job said, "What are you doing?" They said, "Well, it caved in." He says, "No, you'll go back in there or you'll lose your job." Secondary cave-in occurred, killed them both. The operator was a witness, saw and testified. That was a criminal case. The origin of hazard communication was from a case in Elk Grove Village, Illinois, called Film Recovery Systems, and they were using cyanide to recover the silver on negatives and X-rays. They recovered the silver as a precious metal. And when the drums of cyanide came in, even though hardly any of the employees spoke or read English, they removed the hazard warnings from the drums that were actually shipped at the time. One gentleman went into convulsions and died. Actually, horrible story. I don't know if you've heard the details on this. He got so sick, they actually took him in the middle of winter in the Chicago area, dragged him into the parking lot, left him there, and called 911. So you kind of know it when you see it when we talk about these willful.
You ain't like no and see.
Yeah, you really do. Although I agree with Pat, they're tending to overuse it in situations where, but that's a negotiating point. You argue in good faith that this wasn't willful, and on occasion, they'll negotiate the willful to a serious. Egregious, again, you have to earn it. Egregious is where they will, and it's usually egregious combined with willful citations. So when they really want to make their point known, they'll implement egregious, which is every employee who was exposed to that hazard will have the willful citation assigned to that individual person.
Yeah, it's called case by case in some situations. I've never had to defend one of these, and I hope I never do, because one, it means I probably have a really bad client. And yeah, two, and I don't know if this can just get astronomical. So these egregious instance by instance cases come about once every 5 to 10 years, and they're just they're very, very rare. If you're in one of these, you probably have done something wrong.
Yeah, I would agree. And criminal, we talked about this already. It's how many cases are there, Pat? I don't even know.
A couple of things on criminal. So under federal OSHA law, they're very rare. You need a willful violation resulting in death. So anything short of death, you're not subject to it. The reason the Department of Justice doesn't take many of these is because it's a misdemeanor, and they could only prosecute the company. No one goes to jail for this under federal law. So I've only been involved in one my entire career, and we turned it over to criminal counsel because I don't do that. But they're rare. But what is becoming more common are state and local charges. So even though OSHA isn't going to take something, if you and I had one that ended up going criminal in a local jurisdiction on a trenching case, and it's where the local prosecutors come in. They're not beholden to the OSHA law. What they say is this is criminally negligent homicide.
Wow.
and that's a felony, and people go to jail for that stuff. So that's the one you got to watch out for more of. But it does happen. It does happen.
Penalties, people call them fines. The agency calls them penalties. It's dollars. They adjust it now every year according to the cost of living adjustment, COLA. And didn't used to do it that way before. It would it's $7,000, and then maybe 7 years later they realize, well, we need to bump this up, and so they've changed the process. The fines change every year according to the cost of living adjustment. So a serious violation could be issued at $15,625 per violation. So you'll feel the pain for sure. Penalties are actually determined by the gravity of the violation. So gravity is really a function of what's the likely severity of the outcome. If it's a broken fingernail, well, there isn't much gravity to that case, and the frequency at which the employee is exposed. So if it's a fall protection hazard, typically that the outcome is likelihood of death if this is more than 6, 10, 12 feet, as well as the frequency. So if it was one time the employee went out there to do something, that's different than if the employee was working at the edge the entire time. There are so many areas where there is a gray area. I had a thought we were talking about something before. So you're a mechanical contractor. You go through a ladder inside the building to the roof, and you're 50 foot from the edge of the roof. Do you need fall protection? There's actually a letter of interpretation on that, 15 foot. So, but you need to know these things, because if you come up the ladder and you're 10 feet from the edge of the roof, yeah, there's a case where you're going to need fall protection, either a guardrail or personal fall arrest system. So when we're identifying hazards, you have to know how OSHA defines the hazard. You may be comfortable with being 5 foot from the edge without fall protection. OSHA isn't, even though you won't find that defined anywhere but a letter of interpretation. History. If you haven't had an OSHA inspection in the past 5 years, they'll give you a 10% discount. I've never seen it work in reverse, but the policy is that they could increase it by 10%. Good faith. These are the requirements. What's your experience, Pat? Will they just apply the good faith if you establish?
Yeah. I mean, I used to have a running joke with OSHA that as soon as I got the ball, the good discount went away. That's not true. But yeah, they'll typically do good. My experience with penalties is I don't fight about them much because usually you can negotiate them. I don't like to sit at an informal conference and talk about high gravity, low gravity, things like that. Usually we're talking about, did the violation exist? But we have seen lately, I don't know what your experience is, Gary, but they're coming out with maximum penalties in most cases now. When I try and point this stuff out to them, the answer I sometimes get is, well, these are just guidelines. We can deviate.
Yeah.
They never deviate down, but they can deviate up. So I've never had a trial where we're arguing to the judge about the penalty amount, because they've long since put 10 times that into fees by that point. So you're usually not, unless it's a repeat or a willful, arguing about this stuff. But it is good to sometimes hold their feet to the fire and say, hey, by the way, why didn't we get the good faith adjustment? We worked with you. We did all that. And the answer you'll sometimes get is, well, we're OSHA, we can do it.
Yeah, I related the experience as being a little bit like buying a used car when you're negotiating with them. And if you're in there, you're a contractor, and changing a violation from serious to other than serious is going to be beneficial for your opportunities to get future work. The agency may be less inclined to negotiate the amount of the penalty to give you the reduction in
It's horse trading.
classification.
Yeah, and they'll actually tell you, I'll give you one or the other. I'll give you the classification or the penalty reduction. And 9 times out of 10, I tell the client, take the reclassification. What's a few $1,000s, versus a serious. So yeah, but they'll tell you straight up, I'll give you one or the other. And then they go, sometimes they even do it like a used car. I need to go to my manager.
They do. That's absolutely right. So you're in the informal conference, and usually there's the area director and the compliance officer that was involved, but not always either. But they, after you negotiate or state what you're looking for, they will literally get up and leave the room, and we have a chance to talk to the client, and they have a chance to. It just feels like buying a car. Never get the rust protection package, by the way. Always decline. Quick fix. Again, I think this is more of a good faith effort than anything else, that anything that's wrong is taken care of quickly, and make sure you point that out to OSHA. Penalty adjustment based on the number of employees. Again, it makes sense that they would give the biggest discount to the smallest employers because they internally have the least resources to try to deal with all this stuff. When you receive violations. So you have options, right? You can pay the penalty in full by mail. It's an option. Comes certified mail. You have to sign you got it. They know when you get it. You can request an informal conference. You can file a formal contest, which may be appropriate in a lot of cases to jump to that step, or you could do nothing.
Yeah, don't do the last one.
Yeah.
Because if you miss that 15 working day deadline, the citations become set in stone. I've had cases where client comes to me after they missed their deadline by 1 day. I had one where it was a very good excuse. Somebody had COVID and was traveling, and judge didn't care. 1 day late, too bad. And that was a willful case, and so they were just stuck with it. So the last one is never an option. I don't like the first one either.
No.
Just pay it and go away, because just by picking up the phone and having an informal with OSHA, you're going to get at least a penalty reduction and maybe a reduction in all the things we've talked about. As Gary mentioned, there are some circumstances where the case, you just know that you're not going to settle it at an informal. If you get a big willful case, I have the one I have in Nebraska right now. We actually did go to an informal, even though we knew we weren't going to settle. And the reason we did that is because we didn't get the closing conference. So we had no idea what specific facts the willful allegations were based on because they didn't tell us. So I set up an informal conference. We get them on the phone, and I got a little bit more information, still not enough, and then we filed our formal contest. So there's no downside really to requesting an informal. At the very least, you get what we call free discovery. Sometimes they'll open up their file and show you pictures. Sometimes they'll tell you what it's based on. So at the very least, you get a little more information and you establish that good rapport. Even in this case, we strenuously disagree on these willful allegations. I was polite with the area director, say, hey, we disagree. He said, yeah, I know you're doing your job. My hands are tied, but let's talk a little. So you're just kind of setting the groundwork for a good relationship down the road to the extent you can. So, but in my view, there's never a reason not to request the informal. Again, just, a few $1,000 is worth a quick phone call at the very least. And maybe you get something reclassified. And one other thing, and this is rare, but the reason that you want to always settle at an informal conference instead of just paying it and sending it in, if an injury is involved, if you don't get what we call non-admissions language, and it's standard, they'll give it to you without lawyers being involved. It's in every informal settlement agreement they do. It basically says you're only settling this for purposes of OSHA, for repeat purposes or things like that, but you're not admitting that you were at fault for any other litigation. So if you get sued down the road and by a third party or whatever, they can't hold up that agreement and say you admitted that you violated the OSHA Act. If for that reason alone, that's why you want to go through the informal process. So I'd never advise that, hey, I know it's no big deal, just pay and send it in. So I have had a couple where you just knew you weren't going to get anywhere, so you file the contest right away. And sometimes you do it to send a message. Sometimes you think the citations are such bullshit, and they're not going to settle them with you, that the second you get the citations, I file my contest letter the same day. Kind of aggressive, but it happens.
Yeah, and I keep going back to the fact that you want to differentiate yourself from the other employers that don't care about their people. So you show up. You develop a these people are your regulators. If you're working in Colorado, you're subject to inspection from one of the 3 offices. I think you want to be known, but known in a positive way. And they find problems with everybody. If you show up to the informal, you develop that rapport. You show them your commitment to safety in ways you know about. So I always encourage clients to participate in the informal. And I get it. You're not familiar with this process. And it's kind of threatening and kind of unfamiliar, and you don't know what to do. But we've actually had experiences where if an employee stepped up to the plate and admitted they were wrong, even though they may not have had all the elements in place, we've had those employees come to the informal conference and actually admit to the compliance officer that they were responsible for the violation. And, it sends a message that, okay, the employer is not at fault here. The employee is willing to come forward and fall on the sword for what was done. Doing nothing, not a good idea. So, kind of getting to the end of the presentation, and we've touched on these things before, and the reason I think they're so important is because what we're going to talk about is what's called the employee misconduct defense. But fundamentally, if you have those elements in your safety program that comprise the employee misconduct defense, you have the underpinnings of a very good and successful safety program. Because OSHA understands that accidents, 90% of all accidents that occur in the workplace are the result of an unsafe behavior. That's the statistics. Been that way for years. Some argue it's even more than that. 90% of all the accidents are the result of an unsafe behavior. Only 10% are due to unsafe conditions. So if it's an unsafe behavior, that sounds kind of attractive, and you're thinking, well, I can always blame the employee. Well, sometimes their unsafe behavior is on you. One good example is if you don't train your employees, how can they know to do the right thing? And to assume somebody comes to you because they did this job somewhere else and hasn't been trained, that's a big mistake. So if we fail to train our employees and as a result they commit an unsafe behavior, that's kind of on us. But there are things employees do that involve misconduct. So an example would be an employee who violates a safety rule. It's in writing. They violate the rule. They're not using PPE that they've been furnished with. They deny that they were trained. Again, sometimes employees clam up, and even though they've been trained, when they're interviewed by OSHA, they indicate that they haven't been trained. I mentioned this before. An employee who was fired for not following safety rules actually had the nerve to file a complaint with OSHA, and fortunately that complaint went nowhere. So OSHA understands that you can't be looking over an employee's shoulder every minute of every day, and that they are going to make decisions that are not in their best interest and that violate an OSHA standard. They understand that you can't catch that. So the employee misconduct defense was designed entirely to come up with a reasonable protocol in which to determine if you exercised as an employer good faith effort to make sure that that employee does not engage in unsafe behaviors. All of the elements must be in place. And when we show them to you, you're going to say, well, wait a minute, we saw those before, which was kind of the point of me repeating these things. You need to prove that you conduct periodic audits to determine if employees are following those safety rules. And the fourth element is you need to prove that you enforce those rules through some formal progressive disciplinary action process. And, I've asked somebody in the room who actually has a very, very good safety program that unfortunately had a minor incident that occur. But because of all of the good effort that was put into the safety program, was able to avoid any citations. So, Beth, did you want to? I know you're happy about this.
All right. So my name is Beth Lundquist. I'm an owner of Title Lundquist, and I'm also the safety director. So it was actually a year ago tomorrow that we had an injury occur right down the street. It was at 8:15 in the morning. A gentleman moved his drywall walk-up bench, and he, by virtue of driving it across a concrete floor, it unhooked one of the sides. It's kind of like a picnic table latch. It unhooked it, and when he went to step on it, the drywall bench collapsed, and he fractured his left rib, so left rib 3, 4, 5. The long story of it is that nobody would follow our policies and procedures, so the person drove him to the hospital. Unfortunately, at that time, I met him there. We spent all day getting x-rays and whatnot. They kept him overnight, and Gary was my first phone call after I found out that he was going to be hospitalized, wondering if I should call OSHA and file the OSHA complaint on my behalf. And Gary said if they're just keeping him overnight for observation, not to worry about it. I, of course, was in communication with the general contractor. The next morning, I left the hospital about 5 o'clock that night. The next morning, I was back there at about 6:30 in the morning and was sitting there. And at 1:35 in the afternoon, the doctor came in and said that he was going to remain in the hospital for a second night. So at that point, I had to make a decision. I decided to file on OSHA's website, and by 2:12 in the afternoon, we had an OSHA inspector on our website. So I immediately called Gary, and I left the hospital. I was able to get our project manager, our foreman, and Gary and I, and then also our operations manager on site. Luckily, the project was running from 6 to 2, so none of the other workers were there. The GC was notified, and we had our opening conference. After that, the OSHA inspector walked up to the 4th floor where the accident happened. We all took our own individual photos as well as measurements. I had been at the project the next morning, early in the morning, and we had already red tagged and confiscated the drywall bench that was used. It was in the back of my car, and I had taken it to the office before I went back to the hospital. So that piece of equipment was immediately removed. It wasn't there for the inspector to inspect, but we had another one on site that he was able to look at and ask questions about, take photos on. After the opening conference, he said that he was going to stop by my office, inspect the drywall bench, and he actually gave me a list of, this was the list that he wanted. So I had to complete the employer questionnaire. I needed to attach videos or photographs of the accident site. I needed to submit my OSHA 300 and 300A logs for the previous 4 years. I needed a table of contents of our safety health program and manual. I also provided them with a copy of our orientation PowerPoint. Copies of site safety inspections conducted either internally or those conducted by a third party for the previous 3 months on that job site. We use iAuditor. I don't know if you guys are familiar with that. I don't accept 100% audits, and I don't accept anything under 75. If I get an audit that shows that that job site is scoring less than a 75, I immediately shut that down. iAuditor allows you to go in, red tagged items, but anything that's ever red tagged on our audits, there must be a follow-up. So that's the way that we document how we're handling those issues. Copy of safety enforcement or disciplinary policy or program. Copy of our scaffold program because a walk-up drywall bench is considered scaffolding. Copy of scaffold training for employees working at the job site. So we're a union. We push back on our union to do a lot of our training and have to contact the union. I had to get all of the training for that. Copies of the safety enforcement copies of toolbox topics for the 3 months at the job site, and our subcontractor agreement was a general contractor. He sent me that letter 8 days after the initial accident, and I was able to get everything. Thankfully, I'm OCD. Everything organized, and 2 days later, he met at my office, inspected the drywall walk-up bench, and I was able to present him with a packet of information over close to 500 pages, and I emailed it to him as well. We never did a closing conference. It took 3 months to have that closed. There was no citation and no penalty or fine. I thought he was a nice guy. I wasn't intimidated by him. It was a very minor incident that unfortunately resulted in a hospitalization. But Gary is a wealth of knowledge. So if you guys use CCIG, definitely give him a call. He was able to write an amazing cover sheet on my behalf, and we submitted it, and we were lucky that due to our safety firm, we didn't have any penalties, fines, or citations.
Well, Beth gives me way too much credit because I couldn't have done any of that had they not had those programs in place. But the point is, all of you have aspects of your safety program in place. I think in my experience, and Pat, looking for your opinion as well, we see employers do a good job with the written programs and procedures and with employee training. Those two things seem to be something that many companies do very well. Where we do see a disconnect is documentation for routine safety observations and audits, and probably the one that is lacking the most is honestly evidence of disciplinary action. And you don't like to take discipline. It's an awkward situation, but the reality is it's the message that you send to your employees that unsafe behaviors won't be tolerated for their own benefit. It would be different if their unsafe behavior resulted in a claim and you could deny the claim because they did something unsafe, but work comp doesn't work that way, right? I mean, to some extent, there's provisions in the Colorado comp law to discount a settlement, but the reality is, unless you're holding employees accountable, there's nothing to check that behavior. And the agency recognizes that those 4 elements are really important in establishing, because honestly, if the employee decides not to comply with the rules, eventually they can go work somewhere else. But it's a powerful defense that really capitalizes on what I believe are essential elements of an effective safety program. You know, and
Do those disciplines, is there much of a difference between employees versus subcontractor? If you're a QC and showing discipline to subcontractors?
that's a great point. And when I work with a general contractor, and those of you that work with the big general contractors, they kind of impose that on you to the extent that if somebody violates a rule, that general contractor can say that person's never allowed on one of our jobs again, right? So in essence, they're kind of doing the same thing. Or they could withhold payment. There are threats that a general contractor could use much in the same way that the misconduct defense used with an employee.
That's right. And as a matter of practice, it's good to do that. It's good to punish your subcontractors. Unfortunately, the law doesn't recognize the defense of subcontractor misconduct. So all these things we're talking about here are good to enforce with subs. But if they get you on a controlling employer type of deal, you're not going to be able to say employee misconduct. Now, your sub might, but you won't be able to. I'm gonna disagree with Gary just a little bit. I don't like misconduct. I don't like the misconduct defense. The reason I don't is because it's actually called unpreventable employee misconduct, and it's a high bar. OSHA, I mean, you're right. We have been able to go in there and argue it. Judges typically don't like it, but I don't, as a lawyer, I don't like it because it's my burden. I have to prove it. What I like to do, and Gary's absolutely right, where the defense fails is that 4th prong, discipline. It's not enough that you discipline the person that violated the rule leading to the OSHA inspection. you have to show a history of it. So if you show an audit here where we had all these issues going on, but we never disciplined anybody over it, OSHA is going to say, well, you don't get to avail yourself of that defense. And a judge will probably agree. So what I like to do in arguing these cases, even where we could say misconduct, and we still do, we argue what we call in the alternative. What I like to do is say OSHA can't establish that we had the requisite knowledge of the violation. That is a burden that they have. To prove an OSHA violation, one of the things they have to show is that the employer knew or with the exercise of reasonable diligence could have known of the violation. So if we have one of those elements missing from misconduct, say we have the rules, we have the training, we have the audits, but maybe we don't have the discipline. What I like to go in there and say is, okay, maybe instead of misconduct, you OSHA can't show that we knew or should have known that the employee was going to do that day. And that's their burden to prove. So I like to kind of put that back on them. But I agree with Gary 100% that those are the elements that you have to have as part of your program to establish a good defense down the road. In my experience, judges don't like it that much. OSHA will, if you have a good case to put together for them, at informal conferences, we have some success. I just don't like to hang my hat on it at the end of the day because, again, it's our burden to prove. I always like the ball in OSHA's court as much as I can, but to the extent you can rely on it, you absolutely need those elements. And I'll just reiterate what Gary said is never be afraid to discipline people for safety violations. Employers, I get that all the time. Say, well, we don't want to embarrass somebody. We don't want something in their file. But it does send the message that your employees have to know that when your back is turned, they can't be getting away with cutting corners or not wearing their PPEs, things like that, just to get the job done, as Gary mentioned earlier. You have to send that message to them, and not only will it help in a potential misconduct defense, but it's probably going to help negate the issue in the first place, because if they know they're going to get disciplined for it, they're not going to do it, or they're at least going to be less likely to do it. So that's my take on misconduct.
It's a culture. You're implementing the elements of a safety program that will build a culture. And you've got a good culture when two coworkers, somebody who's new to the company, who's on the job, another coworker says, hey, you forgot to do this. You need to wear this PPE. You need to do this. Where you have coworkers not in a supervisory position stepping up to the plate and telling employees they need to follow the rules. And honestly, the point is not to build the defense to get out of a citation. The point is to avoid the unsafe behaviors in the first place that either cause an injury or less likely cause a citation. So it really is an effective element of the program. And I think I'm addicted to the accident pyramid, but basically what the accident pyramid says is that for every one death in the workplace, and 4,300 a year in the U.S.?
Yeah, around that.
Which, if you consider the size of the workforce, is quite an accomplishment. We've gone down as the workforce and the population of the country increases. The number of fatalities, I think we've kind of plateaued a little bit. They're not. If you're one of the 4,300, it's too many, right? But for every one death in the workplace, statistically, this is how the numbers shake out. For every one death in the workplace, there's about 30 serious injuries that are occurring. For every 30 serious injuries that are occurring, there's 300 minor injuries that occur. Not one of us here probably hasn't gone without having a minor work-related injury, no matter what it might be. For every 300 minor injuries, there's 1,500 close calls or near misses. How many of you have near miss programs? And there's a reason, right? For every 1,500 close calls, there's 20,000 unsafe behaviors that are occurring. This is how the numbers shake out. What do we as human beings tend to do? We kind of wait. When did you take care of the problem? Well, when we had an employee seriously injured. Well, the facts are that before that injury occurred, you got people doing the wrong thing over and over and over again. The likelihood is, honestly, that if you do the wrong thing, you're not going to get hurt, but you don't know when your number's going to come up.
I love this slide, Andy. Gary's absolutely right. I mean, the difference between being one of these and being this one is usually dumb luck.
Yeah.
Of all the fatality cases I've had, I maybe had 2 or 3 I can think of where it was just one of those that you can't conceive of how that could have happened. They're usually things that are done routinely. They're things that you hear this all the time. Well, that's how we've always done it, or that's how I've always done it. I've been doing this for 30 years and nothing like this has happened. But the difference between this and that really is dumb luck, a bad day. Who knows? But it's just, yeah, again, purely anecdotal. But I've never had a case where I thought that it couldn't have been grabbed down here.
Yeah, and that's where you and your companies come into play, is doing whatever you can to identify the unsafe behaviors and correcting those. And you don't have to fire somebody when you see an unsafe behavior. You just have to counsel them and let them know. And so those elements of the program are hugely important. I will have to share one last funny story, maybe not so funny. I actually discussed the pyramid with employees, and the employee said, well, wait a minute, Gary, Bill, you'll like this. He said, so let me get this right. I can commit 20,000 unsafe behaviors, and I've got 20,000 chances, then I'm going to have 1,500 close calls. And I didn't have the heart to tell him, but with a thought process like that, I thought he might jump straight to the top of the pyramid. But the point is, an effective safety program obviously is going to help keep your people from being hurt. But an effective safety program is also, whether or not you use the unpreventable employee misconduct defense, is kind of irrelevant, because if your employees are working in a safe manner, that creates less of an exposure of your companies being inspected and cited.
And I don't want to end on a downer note here, but I've been involved in more fatality cases than I care to recount, and these are situations that, God willing, none of you will ever have to go through. They devastate people. They devastate companies. They devastate relationships, marriages. I mean, they're just the worst thing you can imagine. And I don't tell clients this, but I always think, which would you prefer, to be going through this, or to go back a few months and discipline people for what you know is going on, right? I mean, it's just, it goes without saying, and it sounds trite to say, but you do not want to be involved with one of these. It's just absolutely devastating. And I'm not fortunate, but I only see it from the outside. They're not my employees. I'm detached somewhat from the situation, but I see what my clients go through, and it's just whatever you can do on the front end and all the things that Gary's talking about. And again, it goes without saying, and I don't mean to be preachy, but you just have to head this stuff up, because it's very, very troublesome in those sense.
Yeah, I won't even ask for a show of hands, but I've been doing safety for 43 years now. Been involved indirectly. I actually worked on the employer side for 11 years and had 2 fatalities in industry that I had to deal with. But I've been involved in many dozens of fatalities, and it's a horrible situation. And honestly, I can't think of one that couldn't have been prevented. It wasn't the chunk of blue ice falling out of the Southwest airplane that crushed somebody's skull. It was absolutely preventable. And as Pat said, the tragedy that's left in the wake of that, it's just, why did that have to happen? So easily to be prevented. But
I don't like strike warrants, and that was the one I could think of.
There you go.
It was while he was on the job, and there's little you could do. I mean,
don't work in the...
I guess you can. And OSHA investigated, were there work rules in place for weather and things like that?
So that is the OSHA process. We're right at the 3 hours. Does anyone have any questions or comments? Was this of benefit? I guess the way I look at things in life now is, if you leave the room knowing one more thing than when you walked in, we accomplished something. Do you feel like this was worthwhile? The one piece of advice I'd leave you with, and I'd like Pat to chime in here. I would take this, what you've learned, and unless you've already done so at your companies, make sure that key people in the company understand the OSHA inspection process. You don't have to go through the detail that we did, but being prepared and handling the inspection can go a long way in what the outcome is.
Yeah, I'll second that, and I'll say what I always like to end with is, again, anecdotal, in my experience, the biggest mistakes in an OSHA inspection that employers have to deal with happen probably in the first 12 hours. So you need to know up front, be prepared, all the things that Gary just mentioned, because that's where you lose the evidence. That's where your people are making admissions they shouldn't. That's where all the bad things happen. So yeah, an ounce of prevention and all that good stuff. So I agree 100%.
And if you get stuck, there's 2 people you can call. We'd be happy to help you along the way. So thank you for coming. We will be letting you know about future workshops. We're partnering with Sherman and Howard to deliver this content to you. We hope you find them useful. And everybody have a great day, great week, and thanks for coming.